of the money you contribute supports services and programs that benefit all of us in California. When you drive down our many highways, see a police officer helping someone in need, or enjoy a walk along a pristine beach, think about what makes it possible. Whether you're a business owner, making a purchase, or just filling up your gas tank, your contributions are important to our state's economic health. And the greatest part, we're doing it together. We're ready to work with you. Take advantage of our free seminars, helpful classes, instructional videos, and mobile applications. Also, use our online services. It's easy to do business with us from anywhere, at any time. Our partnership equals success. Learn more at boe.ca.gov. Together, we're supporting our communities and funding a better quality of life.
Members of the Board of Equalization want to hear from you. If you have ideas, concerns, or suggestions on how the board could improve services in the taxpayer experience, make sure to attend the annual Taxpayers Bill of Rights hearings in Culver City on April 26th or Sacramento on May 24th. If you'd like more information, visit boe.ca.gov.
Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you. Good for California.
The Taxpayers' Rights Advocate of the State Board of Equalization wants you to know you have rights. As a California taxpayer, your rights are protected during the assessment and collection of taxes, including the right to courteous and prompt service and the right to be treated fairly during all dealings with Board of Equalization employees and officers of the Board. Publication 70, Understanding Your Rights as a California Taxpayer, and Publication 145, California Taxpayer Advocates, can be useful in learning about your rights. If you feel the BOE has not resolved your concerns adequately, please contact the Taxpayers' Rights Advocates Office at 1-888-324-2798 or email us. The Taxpayers' Rights Advocate of the State Board of Equalization. We're here for you.
You asked, and we listened. Together, we've designed a California State Board of Equalization website with you in mind. The convenient login button allows you to access many of our online services from anywhere at any time. Drop-down menus make navigation easy. You can do everything from filing a return and making a payment to finding permits and licenses. Our interactive banners highlight the latest news, programs, and services. Popular topics help you find information quickly. The How Do I and Business Center sections offer you even more helpful resources, including individual tax guides for various industries. We also want to hear from you. Tell us, how was your experience? Your feedback is important because it helps us provide you with an improved and more interactive website. So check it out at boe.ca.gov. It's designed with you in mind.
It's easy to buy things online these days, but did you know you may need to pay tax on those items?
Really?
It's called use tax. And just like sales tax, the use tax you pay to California will help fund important services like public safety, healthcare, and schools. But how do you know if you owe use tax? When you buy things online, look to see if you were charged tax when you checked out. If you weren't, you may owe use tax. It's easy to figure out how little you may owe. For most purchases, you don't even have to save your receipts. Just use this convenient use tax table, available in your income tax instructions. Find your adjusted gross income to see how much you may owe, and enter that amount when preparing your state income taxes. It's that simple. No looking through files and no hassles. You've paid your use tax for the whole year.
That was easy.
Paying your use tax. Good for you. Good for California.
Good morning. Good morning, members and guests. The board committee meeting is hereby called to order. Ms. Richmond, will you please introduce the first committee meeting?
Good morning, Chairwoman Ma and members. Our first committee meeting on this morning's agenda is the Legislative Committee. Ms. Ma is the chair of that committee. Ms. Ma.
Okay, thank you very much. So we are going to open up the Leg Committee meeting for those who are here for the first time. We like to hear the bills that have some sort of nexus or members would like to have a support from the BOE the BOE members, and so this is an opportunity to talk about the bill. We like to ask questions. If we feel strongly about supporting the bill, we will vote to support it officially for the record. If we don't come to consensus, then perhaps we will wait to make a decision whether we're going to support or not. Could come back later on in the process after it passes the second house, for example. So if you don't get the support today, it doesn't mean that it may not get the support. But this is an opportunity for us to also give feedback in terms of how we feel about the bill, for the authors to also let us know if there are any planned amendments along the way, and just so that we can craft a better bill before we go to the governor's office. So that is the purpose for today's meeting and all of our Ledge Committee meetings. And with that, Michelle Pielsticker, Ms. Pielsticker, please announce each bill, and then we will have speakers come and talk about their bill.
Thank you, Madam Chair, board members. Michelle Pielsticker, Chief of the Legislative and Research Division at the Board of Equalization. Our first item is Senate Bill 680 by Senator Wachowski. It's a sales tax.
Ms. Pielsticker? 1458. I think we're going to go out of order.
Okay.
1458?
Yes. Okay, Senate Bill 1458 is by Senator Bates, and it entails a property tax exemption for disabled veterans. The sponsor of the item is Board Member George Runner, and I'll start with existing law. Existing law provides that to be eligible for the disabled veteran's property tax exemption, that the disabled veteran must have been discharged under honorable conditions. Existing federal law, however, provides that eligibility for disabled veterans benefits merely requires that the disabled veteran be discharged under other than dishonorable conditions. This law would expand disabled veterans exemption eligibility by allowing the exemption when the veteran meets all other eligibility standards, as long as the veteran was discharged under other than dishonorable conditions similar to federal law. The revenue impact for this is that for every 100 additional qualifying disabled veteran-owned homes, this bill would result in an annual revenue loss of $126,000. The cost impact is absorbable, and that is SB 1458.
Okay, and we have a speaker here today, Ms. Heidi Wetstein.
Wetstein, thank you.
Wetstein?
Is this on?
Yeah.
Good morning, Madam Chair and members. On behalf of Senator Patricia Bates, thank you for the opportunity to present Senate Bill 1458 to you today. SB 1458 is sponsored by BOE member George Runner and seeks to make California law consistent with federal law so that any veteran receiving service-connected disability benefits at 100% will be eligible to receive the state's disabled veterans property tax exemption on their home. There are currently 5 different types of discharges from active duty that veterans receive: honorable, general, other than honorable conditions, dishonorable, and bad conduct. The problem with current statute in California is that only veterans who receive an honorable discharge may qualify for the disabled veterans property tax exemption, whereas federal statute allows these same veterans to receive benefits if they are discharged under honorable, general, or other than honorable conditions. SB 1458 fixes this problem and gives 100% disabled veterans access to a tax benefit they deserve. Additionally, this bill necessarily helps California veterans returning from war receive a merited property tax exemption as long as they meet the appropriate discharge eligibility from the service. Senator Bates and I appreciate your consideration, and I ask for your support.
Thank you. Any discussion, members?
Yeah, just real quick. I mean, some of the specifics we found as we heard from some of our constituents is even if somebody was discharged like with a post traumatic syndrome discharge, it could be a general discharge, and so then as a result of that, they actually had some harm that they found in their service, and yet under California law, they weren't able to get this. So those are the kind of things that we've found, and we just felt it would be wise to be consistent with federal law here.
And what is the property tax exemption?
Oh, the current
Can
value
you,
of
yeah,
it?
can you explain how that works?
We can always have Steve Kinney come up here.
Sure.
So the disabled veterans exemption applies to the home of a person who, because of an injury incurred in military service, is totally disabled or has lost multiple limbs or is blind. And in general, the basic exemption amount is $100,000, which is adjusted for inflation on an annual basis.
So that's
We didn't need Steve.
So that's $100,000 off of their basis. That's their property tax exemption
Correct.
amount. Ms. Harkey?
I thought I read somewhere, and excuse me, I'm ad-libbing here, but, because I reviewed these last week, but what I thought I read somewhere that we were trying to eliminate the inflation adjustment so that it would just be, there's, it might be another bill.
I think it's another bill.
Okay,
Yeah.
so excuse that. Thank you.
Move to support the bill.
Second.
Okay, Mr. Horton moves to support, have an official support position for SB 1458. Ms. Harkey seconds. Without objection, motion carries. Thank you very much.
Thank you.
Nice job, Heidi.
Okay, and we're taking bills out of order if members come into the chamber just to be respectful of their time. So Tim, 1642 is the next one.
Okay. AB 1642 is by Assemblymember Olbernolty, and it relates to the fire prevention fee due date. Under existing law, annual fire fee assessments are due and payable to the BOE 30 days after the assessment, and the amount assessed becomes final at the end of the 30-day period unless a fee payer files a petition for redetermination within that period. So under the proposed law, we would extend from 30 to 60 days the date that the annual fire prevention fee assessment is due and payable, and provide a corresponding 60-day period to file a petition for redetermination. The revenue impact is an average annual revenue loss of foregone penalties and interest only of $548,000.
Okay, do we have any speakers? Okay, seeing none, any discussion, members? No. Mr. Renner?
Yeah, this is one that, again, I think we've attempted, and I think that we made it partially through the legislature in the past on this particular one. And it just, part of the challenge that we have with this particular bill is because it's 30 days from when the bill date is of the letter, the fact is that people may even receive this 2 weeks after that, or many of these are mountain communities, and they may not even get their mail for a month, and they may not go to their mailbox for a month. And so so it just makes this more reasonable in terms of the amount. It's interesting that it is a large, what is it, $500,000 revenue loss. But again, the issue is, to me, we shouldn't be trying to make our money on penalties. We should trying to make it on the fee itself. And rarely do we have something that's 30 days. This just makes sense.
Just one
Ms. Towers?
Actually, I was going to ask for the BOE regular tax and fees determinations. Is it a 30-day time period to respond?
Yes, for most other BOE determinations, it's 30 days. For the FTB, however, who deals with a significant number of individual taxpayers similar to the fire fee, their deadline is 60 days.
Right. I think the difference is our normal clientele, if you will, are folks who already have a relationship with us. We know how to contact them. We contact them regularly. These are oftentimes very difficult addresses, changed address, hard to find these. And I don't know what we have, about 800,000, I think, are these that we're doing right now.
To go with the additional time period, would we incur any costs as far as system changes?
No, just, minor one-time costs, but when we say minor, it's very minor.
Ms. Harkey?
I would like to see this. It's very necessary. As Mr. Runner stated, a lot of these times, these fire hazard areas are in second home areas, mountain areas, places where people are not, they might go on a monthly basis, and you know, and it's created quite a problem. I mean, this fire fee as it is hotly contested in many areas, and so I think, you know, the fact that we can allow them a little extra time, because in a lot of instances, this wasn't well understood when the fee first came out. I mean, we've had a lot of protests and a lot of people that are upset with it. So I think to the extent that we don't have appeal options here at the board, we merely bill and collect. I would like to give our staff a little bit of a break when they're trying to collect. At least we're being kind of fair and equitable about the receipt time frame, because we don't have any option on an appeal here. It's directly through CAL FIRE, I believe. So, thank you.
Mr. Horton.
Thank you, Madam Chair. I was supportive of the bill last year for the exact reasons articulated by Member Harkey and Member Runner. I'm just a little concerned that the confusion and the different reporting periods that creates and the effectiveness of the education and outreach may be part of the issue here. So even currently, what percentage of the fee payers are paying within 30 to 60 days?
I will have to get back to you on that.
Okay. I think that's important as the bill goes forward to the legislature to be able to codify the exact problem. Some of the information that I've read somewhere, I can't recall exactly what it is, but it indicated that 10% of those who are having it is 10% are having the issue between the period of 30 to 60 days. And so 90% are actually complying within the 30-day period. The other challenge I think happens here is that there's a high turnover. And so given the high turnover, that gives some credence to the necessity for more time in order for them to receive the information and comply. But, you know, my challenge is I just don't have the quantitative data to be able to measure this. But I am sort of supportive in concept. Would like to have that information before engaging myself.
Okay. Perhaps we can move this bill to our next legislative committee meeting and get some more data for clarification, and then we can take another motion to see if we're going to support it. Is that good? Okay, so our next bill, I see Senator Wieckowski is in the room, so let's call up his bill, SB 680.
Senate Bill 680 is by Senator Wieckowski, and it is a sales and use tax exemption for out-of-state purchasers of certain passenger vehicles. Under existing law, we have an exemption from sales tax for a California retailer's sale of tangible personal property delivered outside the state. Existing regulation also specifies that tax does not apply to the sale or use in this state non-commercial motor vehicle manufactured in the United States and sold to a resident of a foreign country who arranges for the purchase through an authorized vehicle dealer in the foreign country prior to arriving in the United States under these conditions. The purchaser has to have been issued an in-transit permit by the DMV, and prior to or at the end of 30 consecutive days from the first date of operation under that permit, the motor vehicle is delivered or shipped to a point outside the United States by the retailer, by their own facilities, carrier, forwarding agent, export packer, customs broker, other person engaged in the business of preparing property for export or arranging for its export. This law would, until January 1st, 2020, exempt from sales or use tax the sale or use of any qualified new passenger vehicle and qualified accessories sold to a person for permanent use outside the state when all of the following conditions apply. Within 30 days after the purchase, the vehicle is moved to a point outside the state. A one-trip permit is obtained from the DMV, At the time of purchase, the purchaser provides the retailer with an exemption certificate, and the purchaser is not a California resident.
Okay, thank you, Ms. Pielziger. Senator Wachowski.
Thank you, and thank you. This is my first time before the Board of Equalization. I appreciate your attention and the fine work the staff did and the amendments to the original staff report that addressed the problems of cheaters or people from California actually trying to take advantage of the law. I see SB 680 as a jobs bill. We know folks that have gone to Germany or have gone to Sweden to buy a Saab or buy a car, vacation there, and then have their car shipped over. And essentially, that's what's going to allow folks to do here in California. It'll contribute to our tourism economy. We just got recent numbers that show San Francisco has done a fantastic job with the tourist trade, and it's an incentive for an out-of-state purchaser to travel to where Tesla is right now, my district, and visit my district, purchase the vehicle, and then travel to Los Angeles, Diamond Point, maybe even Sacramento, and see California before they put their car on a boat, or they just drive it out of state. You understand the hotel, restaurant opportunities that are here. As the staff report points out, under current law, an out-of-purchaser has an incentive to take the delivery of a Tesla in another state where the tax is lower, thereby avoiding the California tax and reducing an associated trip. For this reason, the California Travel Association is in support of it. Currently, right now, Texas does not allow for Texans to purchase a Tesla in Texas. So what they do is they have their point of sale is in Nevada, they go to Vegas, they purchase the car, and then they drive it into Texas. So that we would give them an incentive to come to California to purchase it. I think the electric car industry, and Tesla in particular, is an important attraction for the state and for my district. People want to come and see the cars being produced, understand the economics understanding that the current economics create a deterrent for people to actually do that. It's a solution in a small way to stimulate our economy, and I would appreciate your consideration.
Any questions, members? Ms. Harkey.
I think every time we get these bills, and I do appreciate them, even one at a time, one industry at a time, one dealership at a time, because I think they all point to that, our tax is a little bit too high, and that people would take advantage to move out, and so we try to accommodate that somehow. But I welcome any tax advantage that we can create here in California to stimulate industry. I wish that this were not just Tesla. I think we have a lot of other industries that we might want to look at that are well deserving of attracting out of state. But I appreciate the first effort and look forward to supporting your bill.
Well, as written, I mean, if Fisker and Eureka were still in business, then this would apply to them. But we know that there's Phoenix Motor Cars, Rizani Motors, Super Performance. There are other small manufacturers, and again, they're on the prototype level that potentially maybe they will hit it right and create a product that's attractive to people, but it would not exclude them. As it's written.
Well, I would just look forward to working with you as we examine what else we might be able to pop into something like this that might help stimulate business in Southern California, in your district, and all over.
Thank you.
Because I think there's options. I know we've got, manufacturing exemptions and other things that we do for our companies. We're having trouble accessing those because of different rules and regulations. So maybe if we can just kind of work together to look at what as a whole we could do for industries that we're trying to keep and encourage here in California, I think it would be good. But thank you.
Ms. Towers?
Yes, thank you. Couple of questions or comments. I'm viewing this as a tax expenditure, so I appreciate that it has a sunset date on it. Mm-hmm. I do have a concern that the revenue impact is unknown. And I appreciate that the desire is to increase California tourism. I definitely love California vacations, starting from your district, going to San Francisco, going down the coast, making my way to San Diego, one of my favorite cities. So I really can appreciate having an out-of-state person come into the state and visit California. But unknown revenue impact. And then for this particular exemption, this manufacturer has received a substantial amount of California incentives to stay in the state, going from, they qualify for the manufacturer exemption as it is. They also are a recipient of the California Compete Credit. So at this time, mainly because of the revenue impact is unknown, I will abstain from voting on this.
Yeah, understand that there has been exactly one Tesla that has been bought by a foreign person or an out-of-stater since Tesla started producing. No, now they pay the California tax and then they go back to their home state and they get it reimbursed. So it's really the focus is on the consumer, the purchaser, versus the manufacturer. Although there is obviously encouragement for people to come and touch things as the cars are being built. Okay,
Mr. Renner?
I have a question just in terms of the process, in terms of a normal process. If I was to go ahead, I think there's some forms that I have to fill out. If I buy a car, if I live in, let's say, Arizona, and I want to go ahead and I buy a car in California, but I'm going to take it right back to Arizona, or I'm going to take it back there after a week or two. What's the current process for that right now? Is it do I just sign some form saying I'm not a resident or I'm not going to keep it here, or what is the current law in regards to a purchase like that?
I would like to request.
I'm sure there's somebody out there.
Okay.
Here comes Chief Counsel.
Where's your lifeline? Here he is.
There he is. That's right. That's right.
And I have other people in the room who are welcome to come correct
right.
me if what
Bail
I am
out.
about to say is wrong. But if you take title and possession in California and make the first functional use in California, even if you're from out of state, you're going to be subject to California sales tax. The retailer will be, and the retailer is going to want to seek reimbursement from the purchaser. So, folks.
So there's not an exemption like this if I'm wanting to buy.
No.
No, not presently. So a lot of times, folks from out of state that want to purchase from a California car retailer will arrange for
a
delivery to occur out of state.
So they can't drive it.
Right. They can't make
As soon as they
their first
drive it, then
functional
it's
use of
functional
it
use.
in California.
Right.
Same with airplanes.
So,
Same with.
But there is an exemption for vehicles that are purchased for export to a foreign country.
right, but that's, we've had some of those in appeals. I mean, you basically
It
have
has
to
to be
put them on a boat
irrevocably
and
committed
you can
to
drive
the
them to the
exportation
port.
process.
Yeah, you can drive them to the port as they leave.
Right.
I guess I'm struggling as to whether or not, does this seem to be an advantaging one over another?
Yes.
In this process? If I have a Chevy dealership and I can't sell a car to somebody and they're going to get charged California tax, what's
it's the
what's
manufacturer.
difference?
It's the manufacturer.
Well, it's because that's the way Tesla sells.
Right. Well, but if Chevy were producing cars in California, as they used to in Fremont at that plant, then that may be this bill, as it's written right now, would incentivize.
I think because of the way they actually sell their cars, I don't think they sell direct. So, yeah.
Right. Well, it's triggered on the first sale, whatever that first transaction is. You're right that Tesla has a different model for selling their cars, but those are
currently, right now, if I buy a Tesla in California, I pay the California sales tax on that.
Correct.
What's my ability to? Well, okay, and then I don't pay whatever taxes when I go to take it back to my other state.
Right.
Then other states are lower, so then I'm not going to get hit by the difference usually in the sales tax.
Right. There's no incentive for somebody to do that. Like I said, there was one person that has done it, and I assumed that money was not an issue with that.
I'm struggling with the idea of why have the, I mean, all the things that you said in regards to touring California, going to Disneyland, going to San Francisco, going to San Diego, would all apply to somebody who wanted to go ahead and buy a Chevy.
Isn't this connected manufacturing?
Right, but it's the manufacturing. I mean, I guess if you went to, I don't know what Michigan does, but if you went to Michigan to purchase a car from the manufacturer right there, I have no idea.
They don't use that model. They always, I think that the regular cars don't sell through dealers. You can't buy directly through a manufacturer.
I mean, I know that BMW and Saab, when they were made in Sweden, had those offers for people that you could go there and you would have a 30-day purchase it, have it 30 days to drive it around, and then you could put it on a boat and ship it back here. And, folks thought that it was cheap.
Avoid the VAT and all that stuff.
Yeah.
Okay. I'm just trying to, I get the fact that it's a manufacturer, but I'm still struggling with that kind of having the advantage over one of the other. So,
Mr. Horton.
Thank you, Madam Chair. Thank you, Senator, for bringing the legislation forward. Conceptually, the thought of individuals being able to come into California, transact business, and then leave when the intended purpose is not to use the vehicle in the state of California is a good concept. Any thoughts to expanding it to California residents and to other dealers that are in California, so that they can have the same advantage, a California dealer in California where an individual clearly demonstrates that it's their intent to drive the vehicle straight out of the state of California, no incidental use, similar to what happens with the exportation of a vehicle abroad. Any thoughts about that?
If I understand the question, if somebody was a California resident, but they were moving to Alabama, or they were going to relocate?
The question is twofold.
Vacation.
One, some California residents have dual residency, and so they have a resident outside of the state of California, and they just want a car there, and so they may purchase a car here, drive it directly outside the state of California immediately, and then use it only outside the state of California. In that case, would be the situation that where a California resident could benefit. The other is you have, as some of the members have shared, you have dealers that are located in California. I spoke with the California Motor Car Association, and they expressed concerns about it being applicable, not being applicable to their dealers as well, and so providing the California dealers the same opportunity to have that exemption. The functional use element of the law sort of is intended when a person is going to use it for purposes that is kind of pleasurable purposes, but when they're using it just to ship it outside the state, even though the law doesn't exempt that. I mean, I get that the law says if you're using it on California roads and having the advantage and incurring whatever expenses that may occur here on California roads, then the tax is due. I understand the sales tax element is a transaction tax. I get all that, and I understand the possible necessity of modifying all of these laws in order to accomplish the objective, but anything is possible in the legislature these days.
Yeah. I hadn't thought of the example that you had said, although my analysis would be if they had a Wyoming license and they were California residents, I think under the law as written, they would be able to get that exemption. If the fact that they had dual residency, I just didn't anticipate it. The lucky thing about this bill is that it does have a sunset. So these examples that you just raised and the effect, I'm going to be able to get some data to see how that is actually affecting it. And we'll look into, the dealers that are selling to out-of-state residents here in California in that transaction. I just didn't.
The other option or other potential solution might be to consider expanding our reciprocity with all of the 50 states. When we have reciprocity with the various states, they can actually come in, purchase it, pay the tax in California, take it to the other state, and take a offset against the taxes. So the net effect is zero on them. So I can't recall where we are relative to those relationships, but to expand those relationships will be beneficial to California, beneficial to the consumers as well. So.
Yeah, I mean, I think we have the days of having many automobile manufacturers in California have passed us. Maybe that day will come back again. I don't know what the state of the...
No, the reciprocity agreement is with other states. So I believe we have one with Texas, maybe. Help me out here.
We have a statute that gives credit to purchasers who purchase in another state, and other states have similar statutes. We don't have a compact or anything like that with other states.
So possibly an effort to expand those relationships would be beneficial to California manufacturers as well as California dealers.
Yeah, I will take a look at that because this bill just talks about the first sale. And technically, when that wholesaler buys the car, that's the first sale, and when they sell it to me, that's the second sale, as the way the sequencing goes. So that would be an expansion of what the current system is, because they do buy those cars.
Madam Chair, maybe possibly we can work with the author to assist him in developing a product that addresses all these concerns and something that can accomplish its objectives.
Okay, thank you. Ms. Harkey?
Yeah, I was under the understanding, so correct me, I could be wrong, that this was because we were trying to encourage the manufacturing to stay in California.
Correct.
That's why it's sunsetted. That's the purpose of it. And that it would apply to any other California vehicle, and manufacturers also sell retail. Okay, so I don't know how many of those we've got or if we've got any. I think this is very limited in its scope, and the reason being is that it's kind of a little pilot program. So it's not just a Tesla program. It could be for, I don't know, whoever would manufacture here and sell to people out of state. So I think it's a little broader than we think, but it's definitely not for if you're just coming in and buying a GM car or a Ford that's not manufactured here or something else. Or which we'd love to see. I'd love to see people come here and drive around California and take the car home. But that's not what this bill is aimed at. This is a totally just kind of a little pilot program. And that's why I think the sunset is good, because they'll test to see how we do with it, if we can encourage manufacturing in this avenue. And I think that also would make the revenue loss very minimal initially, just till we know where we're going with it. So I think it's a very narrowly focused bill for a purpose, just merely to try to introduce some manufacturing in California, in the car area, in the vehicle area, with all the new technologies that are sprouting up. We could have hydrogen cars and everything else. There's a lot of new technology. And so I think that anyone who would qualify for this, being willing to manufacture and sell retail actually here in California, I think, this is a kind of a good first start. So I would like to support it, but I don't want to, push the board if they're not comfortable.
Mr. Runner.
Yeah, just a quick question in regards to, I think what happens with this process is somebody would come in California, they'd end up purchasing their car here, they'd drive it around for a month, and then they'd go ahead and register it, for instance, if they lived in Arizona.
Right.
And at that point, they would pay the Arizona sales tax.
Correct.
Ooh. So
You'd have to still pay the tax to California first.
No.
When you first bought it.
No, not under this. Currently, what happens is that they pay the California tax, then they get reimbursed from, there's a paper transaction that goes on once they register their car in Arizona. But they only get reimbursed the portion that they paid in Arizona, not
Right, if
the
it's
whole amount.
7% and it says,
So
yeah.
that's the deterrent, is that they say, well, I'll,
Confusing,
yeah,
time-consuming.
right, and there's just, right, there's a double action that goes on in California at the point of sale. So this would just simply say, you show the proof that you're out of state, you certify you're going to leave in 30 days, you don't have to pay that initial California sales tax. If there's a cheater, we
The
have.
difference is, though, that California, when a sale takes place now, keeps that tax.
Right.
Under this scenario, California would never get that tax.
Correct.
And only Arizona would get that tax.
Right, and there is nobody who's doing that in California now.
do you mean
There's
there's
been
nobody?
one person that has ever done it, because the buyers, even though it's an expensive car, is saying, well, I'm not going to pay California taxes to take the delivery in California when I can just have it shipped to Vegas and pick it up in Vegas and spend the weekend in Vegas and
Right.
drive it to Arizona, or have it shipped to Arizona. In the state, in the Texas example, since Texas won't even allow the shipment of the cars there, then they just go to some other state. And the other states.
But eventually, I assume eventually Texas gets that tax when they drive that car into Texas.
Correct, absolutely.
And then they register it, and then Texas gets that tax.
Right. So my perspective is that we're getting 100% of nothing right now under the current regime. And the idea is that let's do it for 3 years.
Help me understand that, 100% of nothing. Aren't we getting the sales tax right now?
There's nobody buying it. There's nobody actually coming to California
I
and
see.
buying the car. One person has done it in the 5 years that Tesla or whatever, when they were doing the model cars.
Mm-hmm.
Nobody would come in and do the transaction here. Californians would. Okay, that's a different thing because we live here. But nobody from out of the country or out of the state would come in and do it. So that's the concept here, is let's do it for 3 years or whatever the sunset is, and see
Have
if
the new
there's
car dealers taken a position on this bill?
no position.
No position.
Yeah, I don't know if it's that much action for them.
Yeah, sometimes it's the action, sometimes it's the precedent.
Right. Well, no,
Okay.
and that's why we set it up as a sunset to say, okay, let's see what happens here.
Okay.
Do we have any numbers on?
Okay, Mr. Horton.
The other thing I would encourage staff to sort of take a look at is the Cutler case and the constitutional provisions of providing an out-of-state resident something different than what the California residence has. And we just went through that process where in the Cutler case it was deemed to be unconstitutional to do that. And then, of course, the provisions of just shipping the vehicle outside the state. We have existing laws that allow them to, I think it's a law, Cindy Martinez, as I recall, passed a bill that allows a dealer or manufacturers to let a person drive a car for a few days as a test drive to see if they like it, take it back to the dealer, and the dealer could ship it outside the state, presuming that a sale wasn't consummated in that process. Just another law.
So I'm hearing there's a lot of questions and not unanimous support at this moment. So perhaps we can get a little more data and drill down and see whether this is a real problem, and maybe the statistics are there in terms of how many cars are actually getting shipped out of state.
Yeah. There has been no formal opposition that I know of to the bill.
Okay.
But I'll leave it at that.
I encourage you to continue. We just get a little more information.
Yeah, so maybe we'll have you back, or Mr. Greaves will come back at a future meeting.
Thank you very much.
Okay, thank you, Senator. Okay, our next bill will be AB 1858.
Okay, AB 1858 is by Assemblymember Santiago. It relates to an unlicensed auto dismantling task force, and it is sponsored by Board Member Horton. Under existing law, auto dismantlers must be licensed with the DMV to have an established place of business. And to obtain an auto dismantler license, the applicant must provide a seller's permit number from the BOE, among other things. A licensed auto dismantler is presumed to be making a retail sale unless the seller has a resale certificate from a licensed dealer, dismantler, automotive repair dealer, or scrap dismantling industry. The Revenue Recovery and Collaborative Enforcement Team, which includes the BOE, FTB, EDD, and the Department of Justice, work cooperatively to pursue criminal tax evasion resulting from underground economic activities that evade state taxation. And the Joint Enforcement Strike Force and the Labor Enforcement Task Force focus on noncompliance related to labor in the underground economy. BOE is an active member of these two task forces. Under the proposed law, the DMV would be required to establish the Unlicensed Automobile Dismantling Task Force, which includes representatives from the BOE and Cali, PA. The task force would be required to collaborate to investigate underground unlicensed auto dismantling that violates the law, resulting in tax evasion and environmental damage. And this also requires a report to the legislature regarding the number of leads and complaints generated by the task force and recommendations for statutory and regulatory changes to further enforcement, and it sunsets January 1, 2019. There's no direct revenue impact, but to the extent it addresses tax evasion, there may be some positive state and local revenue impact.
Okay, thank you. The speakers I have is Mr. Gavin McHugh and Mr. Rob Dumas from the State of California Auto Dismantlers Association, as well as Marilyn, sorry, can't read it, Limon?
Yes.
Limon, Ledge Aid for Assemblymember Santiago. So perhaps we'll start with you.
Okay. Okay. Hi. Thank you. And on behalf of the Assembly member, I'm here to request your support for this important bill that really will make a difference and is really close to home for the Assembly member. So that said, I'll pass it over to Gavin.
Madam Chair and members, Gavin McHugh on behalf of the State of California Auto Dismantlers Association. First, we would really like to thank the board and staff for all the good work and help you've provided over the years to us in trying to address this ongoing problem of unlicensed and unregulated activity in this area. You've always been receptive and open to help and our suggestions. Unfortunately, the reason we're back today is this problem of unlicensed, unregulated dismantlers is continuing to grow and worsen. We're now losing about 40 licensed auto dismantlers a year in California, which is a very troubling trend. So we've basically decided to approach the legislature, and Mr. Santiago has agreed to take on this issue of a task force to get sort of the multi-agency attention that we think this issue addresses. We believe approximately, and this is a very conservative estimate, but we think approximately 360,000 end-of-life vehicles are now going into the underground economy every year in California. There's a lot of consequences with that as it relates to environmental damage, unsafe workplaces. A lot of this is occurring in underserved communities in California, as well as a significant, and we're going to talk a little bit about this in a second, the significant uncollected tax in the state that is also creating this growing advantage for these bad actors. The task force is made up of basically three entities. DMV would be the lead because we are licensed through them occupationally. BOE obviously has a role because of the tax implications. And then Cali, PA is an important part of this as well because under their umbrella there are four departments and boards there that actively regulate licensed dismantlers. First being the State Water Board, where we have our stormwater permit. It's a very costly but important regulation that we're required to have through our stormwater permit. Then there's the Department of Toxic Substances Control, where we have to have our hazardous materials business plan for all of the hazardous wastes and materials we process from end-of-life vehicles. And then, of course, the Air Resources Board, as it relates to catalytic converters and what has to be done with them at the end of their life, as well as Freon, which is a highly volatile greenhouse gas, and the regulation and the requirements we have around that. And then, of course, Cal Recycle that handles tires. The issue here is that all of these requirements have a lot of cost associated with them, and what you'll have is a unlicensed dismantler who's essentially doing the same thing that Ron Dumas does, who's a licensed dismantler, but has none of the cost. So they have a very huge incentive to go to the underground economy. We have a growing coalition of support for this measure that includes local law enforcement, the industry supporting it, local government, and then now we're receiving a lot of support from the environmental community who are recognizing the impacts to public health and so forth. So with that, let me pass it over to Ron here, who is a licensed dismantler in Roseville and can speak to some of the tax issues and how he sees this impacting his business. Thank you.
Hi, thank you. Hope you can hear me okay. I'm here hopefully to explain anything you may not understand about our industry and what we're going through, but the effects are right now, as Gavin pointed out, we're losing what was already a small number of dismantlers. We're losing approximately 40 a year. And this has been increasing over the last few years, and it won't be long before the last remaining, especially independent dismantlers, aren't going to be able to afford to operate in this state. And the issues that Gavin was talking about, regulation, have a significant impact on our ability to compete with the unlicensed, who not only have the benefit of not paying the costs of the regulation that we have to pay for, but they get the added advantage of being able to sell their goods, and they're not collecting sales tax in many or most cases. For myself, my business, not probably average for the independent businesses, we collected and submitted over $100,000 last year in sales tax. And what we're estimating, which is part of the bill, is that we believe that the state of California is losing maybe north of $100 million a year in lost revenue that could be collected, or at least pushed back to the licensed community where it would be collected if some of these enforcement suggestions would be to take place. So with that, I do thank you for your time today, and if there's any questions, I'd be happy to try to answer them.
Yeah, and maybe you can just explain a little bit about your business, like who brings in a car, what do you do with it, what kind of fees, how do you pay them, or how do you register with these agencies?
Okay, I guess starting with the registration first, becoming DMV licensed. It's nearly impossible today to get a dismantler's license due to the high costs and the fact that most communities, like other businesses sort of like ours, they don't want them in their neighborhood. So it's very difficult and costly. And so to get a license like I have today, I would never get it in the city of Roseville, probably Placer County, and Sacramento County is increasingly difficult. So these auto dismantlers are going to tend to be in low-income areas where there's the least opportunity for the communities to properly enforce what might be going on anyway, even with the licensed community. So as we're dealing with the regulation and what we're, the way we get our vehicles in is going to be we may buy them from you as your car just, it fails on you. There's an opportunity for us to buy that car from you. We'll buy from auctions, we'll buy from dealers, sometimes tow yards. So any of the vehicles, end-of-life vehicle that we deal with, it can be end-of-life. It could be a brand-new car, and a lot of times those will go to an auction, one that's been damaged beyond the point of being able to repair it economically. Did that answer?
Yeah, so then it comes into your yard, and then what do? You totally take it apart and then sell certain things, or you have to recycle other parts?
We do all of that. One of the environmental benefit of having licensed regulated auto dismantlers is the fact that one thing right off the top, as you mentioned, we recycle and we reuse. So we allow the reuse of parts that prevents the need for manufacturing and also helps protect the environment the way that resources don't have to be. We don't have to go and dig more ore up. So there's the automobile is recycled up to 95% of the vehicle's weight is reused again, over and over again. So there's a recycling side of what we do. The other aspect you asked about was parts. So we sell parts to the community, and those parts are removed from the cars. As in the process of doing that, one of the first steps in removing the parts from a vehicle is for us to depollute the car. That's removing all the things that Gavin was talking about. It's oil, tire, freon, brake fluid, all the things that can be a hazard to the environment. We have to document what happens to all these items. We have to manifest it, make sure it's shipped properly, pay for those, pay for the disposal of tires and things like that. So there's all those impacts we are closely held to do. The purchasing of vehicles, even through the Department of Motor Vehicles, the disadvantage that we have as a licensed entity is we have a waiting period from when we buy a car. So when we buy a car, it can take us up to 10 days to actually begin any process on that vehicle. The unlicensed community can virtually start the minute they get the car, before they get the car, begin making transactions where they sell their parts on Craigslist and eBay.
Yeah, kind of like the pawnbrokers. You have to hold it for a certain amount of time, make sure it isn't stolen, right, before
Right.
you can actually
Exactly.
take possession and
And
use it.
We actually have to document the arrival and that we have the car and wait for DMV's process to catch up with the fact that we have that car.
So my question is, so this task force is needed to document, figure it out, bring people together? I mean, I know we've been trying to tackle this industry for many years. Why do you think this idea is going to work?
Well, you know, we've done a lot of sort of one-offs. We've had a lot of meetings with the different agencies. You folks tried to address this and helped with the tax cap legislation at the insurance auctions, which helped. We've met with the directors of these agencies, chairs of these boards. Everyone agrees it's a problem, and they don't challenge us on our data or the issue. We think because of the complexity of this problem and the size of the problem, we need to bring sort of a joint effort together where the right folks can get in the room, identify the problem, share information, and then go forward with actual enforcement. And through that, learn what needs to be done or changed in the law to make it work. So essentially, they're going to spend a year actually doing enforcement. That's the way we believe the law is crafted, and then come back with recommendations. I mean, they may determine that it's not a problem. We don't think that'll happen, but I mean, they have the ability to do that. But we just think that it's time to get everyone in the room, all the regulatory agencies that regulate, inspect, audit his business, that are responsible for all these materials, this regulatory requirement to work together. We think it'll be a success.
Yeah. Is there a cost estimate to this, creating this task force?
We have identified that the cost is absorbable.
I'm just wondering, do we normally pass legislation to create these type of task force? I mean, I'm wondering why can't the agencies just decide that this is important and allocate people to work on it versus going through the legislative process?
You
I
want
can
to
respond.
respond? I
Sure. I mean, without creating, you know.
I agree. The problem is that oftentimes getting these agencies to cooperate, they need then to have a
Legislation.
direction from the legislature, and the challenge will be, I would assume, will be getting the governor to agree.
Yes.
If this comes to his desk, without saying, well, why can't they do this on their own? When indeed, oftentimes, it takes a prodding from the legislature to actually get these agencies. I'd agree. Wish we could all call up together and have a meeting. Unfortunately, it doesn't work. Sometimes it doesn't work that way.
Yeah, Madam Chair, the unfortunate reality that we face in many cases, in order for agencies to collaborate, it requires legislation, and in some cases it requires memorandums of understanding. Historically, this dates back, the formation of these task forces for the Board of Equalization dates back to almost 30 years when we formed the first joint enforcement task force to deal with the diesel fuel criminal and loss of funds in the diesel fuel areas, as well as the issue in the underground economy. This is probably one of the most regulated industries in the nation. As a result, it becomes ripe for criminals because criminals can avoid the regulations, they can avoid the taxes, and all of a sudden their profit margin, whereas the legitimate operator will have a small profit margin, if you don't pay your taxes, you don't comply with the regulatory provisions, you don't comply with the environmental provisions, then all of a sudden you quadrupled your profit margin. The downside to this element of greed, if you will, and manipulation that occurs is that it affects the environment directly because they're not complying with the environmental protection requirements, they're not complying with the tax law, and so Mr. Runner is absolutely correct. When we did the legislation, I think a couple of years ago, to establish the TRACE program, we went through the same challenge with the governor about the necessity exists. I think everyone acknowledged that the necessity exists, that the agencies are not collaborating, they're not working together, and so the necessity for such a task force exists, but the thoughts were at the time that we could kind of merge that into the existing task force, and why create a new task force? We were able to explain to the governor that the existing task force deals primarily with labor violations, whereas sales tax violations is something unique, and you need the authority of the Board of Equalization and the taxing agencies to be involved. The uniqueness about this task force is that it has more of an environmental protection component, which Trace doesn't deal with. But based on the studies that we've done here at the Board of Equalization, which is a concern about the revenue estimates, I believe there should be a revenue increase to the state of California, given the estimate by the industry of a loss of $100 million. 10% recapture of that is a revenue increase. And historically, every task force has proven to be successful over the last 30 years. And particularly RACE and TRACE, current task force operated by the Board of Equalization, are extremely successful in generating revenue for the state of California. So the other concern, members, is as the representatives articulated, many of these dismantlers are located in minority communities. So it's more of an environmental justice issue where it's affecting those communities, the contamination that exists by individuals not complying with these laws. So it's a huge issue. So the $9 billion that we estimate we're losing to the underground economy, this is only a fraction of it that I believe this task force, partnering with and working with the other task force, once they get to that level where they've accumulated the information, they've established the ability to collaborate and to share information, and then I believe collaborating with TRACE, the existing Board of Equalization, to have that enforcement component will prove to be extremely valuable to the state of California. Lastly, this may be one of the dying industries, manufacturing industries in California. Because, yeah, in fact, I mean, it's kind of sad that we say this. This is one of California's manufacturing industries, because you're actually recycling used parts, and you're assembling them, and you're distributing them, and you're selling them. So we need to preserve that industry.
Ms. Stars.
Just one question. I appreciate you explaining the difference between TRACE and RACE, because I was wondering why not go right to them. If the task force is established, will they be going after criminal charges or just regular unpaid tax penalties or violations of the regulations?
All of these, the greed that exists and the manipulation that exists is an unfortunate part about tax evasion at this level. They don't stop at sales tax. They criminally violate the environmental laws. They criminally violate the tire assessment fees. There's a loss of tire fees, a loss of sales tax, loss of property taxes. So when you begin to add these all up, it begins to approach very rapidly the criminal component requirements. And so these would be criminals that the agency would be going after. The initial step, though, is to establish the collaboration and to begin to gather the information. The thought is to approach this from an intellectual perspective so that we intellectually can deal with and identify where the problem is, and then you're able to articulate to the legislature what the exact needs are. There's quantitative data that exists that supports that this is a huge problem, and there's empirical data as well. But I think the appropriate step that the industry is taking is to form the task force and then to begin to go after the criminals afterwards. But as I shared earlier, I believe the criminal investigation would probably be elevated to TRACE and probably be elevated to another component within the Board of Equalization, Internal Revenue, Franchise Tax Bureau, Environmental Justice, and the other 30 agencies that are impacted by this.
So I appreciate your explanation. I think another big issue that I've heard is the used car dealers, not the used car dealers that are connected with the new car dealers in terms of licensing and getting the taxes, but the independent ones that are in the community not actually registering. And so from what I'm hearing from you, in order to get people to work together. We kind of need a task force to bring people together, similar to this, to tackle this problem, because I think it is an issue, and the agencies aren't working together necessarily to actually put resources and priorities to this. So I appreciate this explanation, because I've been trying to work with it on the outside, but it hasn't gone anywhere. So maybe the task force is where I need to look into. Ms. Harkey.
I would make a motion to support the bill.
Second.
So I guess there's support and there's sponsor.
Sponsor.
Sponsor is a little stronger.
Sponsor. We can sponsor.
Everyone sponsor? Okay. Ms. Harkey made a motion to sponsor. Mr. Horton seconded. Ms. Stower seconded. Okay, without objection, our board will actually sponsor this bill. So
Thank you.
let us know how we can be helpful. Thank you.
Thank you very much.
Okay, our next bill is AB 2518.
AB 2518 is by Assemblymember Gomez, and it involves a sales tax exemption for low-income housing charities. Existing law imposes a sales tax on all retailers for the privilege of selling tangible personal property at retail in the state, or the use tax on the storage, use, or other consumption in the state of tangible personal property purchased from a retailer. It does not provide an exemption or exclusion for the sales and purchases of building materials, supplies, equipment, or machinery to be used for the construction of homes sold to low-income households. Under this proposed law, we would exempt from the state sales and use tax the sale to or purchase by a qualified nonprofit of building and construction supplies, materials, equipment, and machinery, including parts purchased for use by a nonprofit corporation for construction of properties that are sold to low-income families. To be eligible, a nonprofit corporation must be exempt from paying federal income tax under Section 501c3 of the Internal Revenue Code. And additionally, the nonprofit must qualify under Section 214.5 of the Revenue and Taxation Code as a corporation organized and operated for the specific and primary purpose of building and rehabilitating single or multifamily residences for sale at cost to low-income families, with financing in the form of a zero-interest rate loan and without regard to religion, race, national origin, or gender of the head of the household. The revenue impact of this proposal would be an annual general fund revenue loss of $87,000, and a cost estimate is pending.
Thank you. We'd like to welcome Annabelle Snyder, Legislative Director for Assemblymember Jimmy Gomez, as well as Nicole Wertelman, representing Habitat for Humanity.
Thank you. Is this on?
Yes.
So, thank you for allowing me to speak today on behalf of Assemblymember Gomez. We are asking for your support of AB 2518, which would provide a state sales and use tax exemption for building and construction supplies, materials, equipment, and machinery purchased by a nonprofit corporation for construction of properties sold to low-income families. As you already know, California is one of the most expensive places to live. Approximately 95 million American families suffer from housing problems, including high-cost burdens, overcrowding, and homelessness. 1 in 3 households spends more than 30% of their income on housing, and 1 in 7 spends more than 50%. Local governments deal with overcrowding and congestion. Employers struggle to attract and retain the labor force that is so vital to their bottom line. Low to moderate income working families work longer hours, endure longer commutes, or cut back on basic necessities in order to pay for housing. Affordable homeownership helps families, builds wealth, and strengthens communities by providing substantial economic benefits to the homeowner, family, their neighborhood, and the economy. Several studies have shown potential benefits of homeownership to be better education outcomes for children, lower community crime rates, less welfare dependency among households, more household participation in civic affairs, and finally, better household health. This is the Assemblymember's goal to increase construction of affordable housing in California. AB 2518 is a modest step toward this goal. Thank you for this opportunity. We look forward to this discussion today. And here with me today is Nicole Wertelman, who is a legislative advocate for Habitat for Humanity, who is in support of the bill. Thank you.
Thank you, Nicole.
Hey, Nicole Wertelman on behalf of Habitat for Humanity. First, I wanted to thank very much the staff for the analysis. I know they had to work hard on it with all the numbers.
Habitat for Humanity of California has 45 affiliates, more than 50,000 volunteers that build, renovate, and repair more than 600 housing units every year. One of Habitat's biggest challenges right now is that we don't have a dedicated funding source in California for home ownership for low-income people. And AB 2518 will help Habitat to be able to build, renovate, and increase the number of houses and home ownership for long-term housing stability for low-income people.
Thank you, members. Mr. Renner.
It's a quick question. Is this a partial tax exemption?
Correct.
So this does not include the local portion? Is that what that's?
That's correct.
That's correct.
I just find it interesting that, again, the local folks are the ones that actually help make these projects successful, and actually have the greatest benefit by having these homes, and whether it's Habitat for Humanity or whatever come in. I know, at least in my communities where they're engaged, that communities are very engaged. I just find it kind of interesting that they're not willing, that at least the bill isn't willing to have them use their portion of the sales tax to help support that. So I don't know if you've had discussions with local governments.
Not yet, but we can definitely.
You could do that. I would. I mean, again, I think I think the project's right. I think it's a good thing, and I would hope that the local governments would be as supportive of this process, because they really are directly benefited, and these projects only happen successfully when the local governments are engaged with other kinds of waivers and fees and things like that are part of it.
Thank you.
Thanks.
Ms. Harkey.
I think the reason the local government isn't part of this bill is that's a whole separate administration, trying to get all of them on board either through league or their separate organizations. So or county by county.
Sure.
So I think this is like a first step, and maybe the next bill could be conformity with state law regarding, a conformity bill for locals that might be a little bit easier for them to accept. But I think that it's a good effort, and I appreciate what you're doing. Thank you.
Ms. Towers.
Yes, thank you. I also agree. I think it's the right step in the right direction. Does it have a sunset date?
No, it does not.
This too is a tax expenditure, and I think it's a great one, but I would like to see some type of look-back measurement to see how effective it was.
Yes, I would too.
Okay. We could definitely discuss that with the Assembly member too. Yes.
Mr. Horton.
Thank you, Madam Chair. This is an exceptional bill. I'm glad to see it come forth. The challenge California has is the price of homes are rising rather rapidly. We are approaching the recession level prices of homes. In Los Angeles, the average medium home is around $473,000. San Francisco, $1.2 million. And the reality that we face in California is 70% of our residents can't afford to buy the average home. And so I think all the economists are projecting that in order for California one of the steps that California has to take in order to avoid a recession is to be able to create at least 1 million new affordable homes for those who can't afford it. And the face of poverty has changed. It's not the seniors and uneducated. These are college graduates that can't afford to purchase a home. Arguably, everyone in this room wouldn't be able to buy their home at the current selling price of their home. And so it's a challenge that we face. This is an inexpensive way to begin to meet those challenges, and I would move that we support the bill.
Okay, Mr. Horton moves.
Second.
Ms. Stowers seconds. Without objection.
Given the caveat, my apologies, but given the caveat
The sunset date.
That,
sunset date, and they entertain the local tax as requested by Member Runner.
okay.
Yes, and we made a note of both of those.
Okay, great.
Yes.
Thank you so much.
Thank you.
Okay, so motion carries. Next, Ms. Peel's ticker is AB 2570.
This AB 2570 is by Assemblymember Quirk. It is cleanup to the property tax requirement that the Public Utilities Commission send their audit reports to the BOE. Under existing law, the PUC is required to inspect and audit the books and records of public utilities for regulatory and tax purposes, and existing law specifies that audits conducted in connection with rate proceedings fulfill the audit requirement. Existing law requires the PUC to furnish these audit reports to the BOE for use in the assessment of public utilities. The proposed law would, until January 2nd, 2017, delete the requirement that the PUC furnish its audit reports to the BOE. The BOE has actually not accepted these audit reports for many years and finds them to have no value in the assessment of public utilities, and the state auditor also recommended that this provision be deleted, as by not furnishing the reports, the PUC is out of compliance with the statute.
Okay, thank you. Mr. Brady Borcherding, Legislative Aide for Assemblymember Bill Quirk. Welcome.
Thank you. Good morning, Madam Chair and board members. I'm here this morning on behalf of Assemblymember Quirk to present AB 2570 for your consideration to support. Existing law requires, first, AB 2570 responds to a 2013 report by the California State Auditor that recommended repealing the CPUC's requirement to transmit audit reports to the Board of Equalization. Existing law requires the CPUC to inspect and audit the books of records for regulatory or tax purposes of a utility serving over 1,000 customers at least once every 3 years, and to provide the inspections and audits to the BOE for the BOE's use in the assessment of public utilities. However, the state auditor found that the CPUC has not always complied with the requirement to audit utilities books and records according to the schedule prescribed by state law, or on a schedule that is at all beneficial to the Board of Equalization. And for over 3 decades, it has not provided the results of these audits to the California State Board of Equalization for tax assessment purposes as required by law.
Controversial bill.
As such, the audit recommended eliminating the CPUC's requirement to produce and transmit these reports to the BOE.
Nobody's doing it.
Assemblymember Quirk agrees with the auditor in repealing these requirements. By repealing the requirement for these inspections.
Thank you. So we have a motion by Ms. Harkey, a second by Mr. Runner, to move this bill, support by the BOE. Thank you very much for coming and
thank you so much
for your time today.
It was embarrassing disclosure. 30 years, nobody's been doing it. We're just catching up.
The next bill will, for discussion only, will be SB 987 by Senator McGuire. I see that Mr. McGuire's Chief of Staff just showed up, Mr. Jason Lyles.
Thank you.
We're going to have Ms. Peelsticker read the bill first and then have you present.
Thank you, Chairwoman.
Thank you. SB 987 by Senator McGuire relates to a marijuana value tax. Existing law imposes the sales tax on all retailers for their privilege of selling tangible personal property at retail, or the use tax on the storage, use, or consumption in the state of tangible personal property purchased from a retailer. Because medical marijuana is tangible personal property that is not otherwise exempt, it is subject to the sales and use tax. Under the proposed law commencing January 1, 2018, we would impose a 15% tax on medical marijuana purchased from a retailer of medical marijuana. Revenues are allocated as follows: 30% to the general fund, 30% to the Bureau of Medical Marijuana Regulation for grant program administration, to distribute grants to local agencies that oversee the regulation of cultivating, processing, manufacturing, distributing, and selling medical marijuana upon appropriation. 20% to the Department of Parks and Rec for base state park operations upon appropriation by the legislature. 10% to county and city human service departments for drug and alcohol treatment programs, which are distributed based on population upon appropriation by the legislature, and 10% to the California Natural Resources Agency for restoration and remediation of public and private lands and watersheds damaged by medical marijuana cultivation, including lands affected by medical marijuana cultivation before the operative date of this section upon appropriation. The revenue impact of this proposal, assuming 100% compliance, is an annual revenue of $251 million. And of course, that would need to be adjusted based on actual compliance. The cost impact to the BOE would be $3.1 million for fiscal year 2016-17, $5.4 million for fiscal year 17-18, $5.1 million for fiscal year 18-19, and $4.8 million for 2019 to 2020 and ongoing.
I'm sorry, this was the cost of the BOE?
Yes.
And for what?
To administer the new tax. It would be a new tax program.
And also with the different agencies not able to, the agents, I guess the industry is not able to bank yet. So therefore, the agencies would all have to accept cash, presumably, or the BOE or some other agency would accept the cash. Is that also incorporated in the numbers?
Yes.
Okay. Thank you. Mr. Laus.
We're counting on the chairwoman to solve the banking problem for us. No, I understand what a huge issue that is. First of all, I apologize for the senator not being here. He's presenting in committee today, and unless he's behind me, you're stuck with me today. Thank you very much. I also want to do a quick thank you to the technical staff at the BOE. We've been working with their staff for the last 3 or 4 months, kind of going back and forth on some of these issues. And Mr. Richard Parrott, Cindy Wilson, and of course, Michelle has done an amazing job of helping us kind of guide through the technical aspects. You have a real good breakdown from what Ms. Spielsticker talked about. I think the only change that in the expenditure of the revenues is that we've taken out the 10% that goes to natural resources, because we're trying to complement Assemblyman Wood's bill, who has a provision in there for a very similar item, and we're taking that 10% and putting it into the drug and alcohol treatment programs. So for now, it's 30% local law enforcement, public safety, and local governments, 20% drug and alcohol treatment, 20% state parks, and 30% to the general fund. I understand that the BOE has some concerns about the upfront implementation costs. It makes complete sense to us, and also the ongoing costs to make sure that they get reimbursed, and I think we can take care of that in appropriations. Appropriations staff is already very well aware of that and working with us to create language. The other concern I know is where in the supply chain this tax is implemented, and staff has been pretty clear about where the BOE would like to see it as far as sort of making things easier and less expensive on the industry and on the state. And I think we understand that. I think right now, given the way the industry is, in kind of going through the motions and in meeting with most of the industry and with the regulators, the folks that are soon to be regulating this under our legislation from last year, it seems like that's not quite ready yet. And we may be a few years away from actually being able to do that. So our goal is to have this tax at the point of sale once everything is set under the regulatory framework that we established last year that goes into effect in January 2018. And that's working. I think we'd be really willing to revisit. Our goal is to kind of make it as easy as possible. My boss represents the 4 counties that supply maybe 60%, along with the chairwoman, the marijuana for the entire country. And nobody is more eager to make sure that this industry goes into the light than my boss and his constituents. This is just really, it's been a long road, 40, 50 years of a lot of problems, some good things, and a lot of issues in our district. Creating a regulatory framework is something that we worked very hard on last year, and it's very important to us. The last thing in the world we want to do is try to keep people in the dark. There are some folks have said, and please stop me, Chairwoman, if I'm going too far. A couple of the issues that have come up are that the total accumulated tax is too much. 15% from the MVT that's in front of you today. Assemblyman Wood has a cultivation tax. You've got a sales tax, of course, and then local taxes. We've done our homework pretty well on this, and I think that what we've seen in trying to learn our lessons from other states is that 2 things. Number one is if you put the tax too high, like Washington State did, and like even what Colorado did originally, you create a big problem and people stay in the black market. Our goal is to make sure that people come into the light. The sweet spot for that is somewhere between 30 and 35% from what we've been able to tell and in talking to other folks in other states. So our goal is to make sure the total accumulated tax stays under that. The other aspect is that looking at the evidence from the other states that have created a regulatory environment, the other 22 states, the price drops between 10 and 40% depending on which state you're talking about and what regulatory process they have once it becomes regulated. And then we're talking about just medical marijuana right now. So you combine those 2 things, I think we're safely under. We're trying to keep it under 30%. I think 35 is, an outside number. We're trying to keep it under 30%. So it's a big concern of ours. And the last thing I want to reiterate, the last thing we want to do is keep people in the black market. So if our percentage, if somebody shows us that our percentage is too high and it keeps people in the black market, we're certainly willing to talk about it. One other concern is that if the leading initiative that's out there that we've all heard about actually passes and our bill passes, then You've got double taxation, you've got a huge amount. Again, not our goal. We like the marijuana industry. We want to make sure that it succeeds and stays in the light. We put an amendment into our bill to make sure that if that initiative passes, our bill becomes void. The last issue that we're working on right now, major issue that I think that we still need some work on, is the patient protection provision. Right now, everybody is forced into the patients to be a patient, basically, in California, based on the way the system is. Some folks want to use it recreationally. They're forced into the medical system. Our goal is not to tax people that are truly needy from a medical standpoint. Our goal is not to tax people who are financially needy and need this medicine. If we could find a way to make sure that those who have a true medical need were exempt from this tax and even sales tax, we would be okay with that. It's a very difficult thing, as you know better than anybody from a taxing perspective, to kind of find that spot. It's easier to find financial need by using CalFresh or using a Medi-Cal card and exempting those folks who have those, but it does create some other issues and some stigma attached to the Medicare card, and we're in talks with those folks in the administration and with people in the community to try to make sure that if there's a way for us to exempt them in this bill, we're willing to do it, but we don't have any agreement on how that works right now. Lastly, I'll just sum up and say that, again, very, very important that people come into the light on this thing. Nobody has more constituents dealing with this than us, except for maybe the chairwoman. And we will willing to work with the board on each of the items that they have an issue with as it goes through the committee process, and we'll be in front of the Government and Finance Committee next Wednesday.
Thank you very much. Okay, members, Mr. Runner.
Yeah, a couple of observations. Obviously, these particular bills, because they are tax related, obviously need a broad support over in the legislature.
They do.
And I know there have been concerns about some of the issues in this particular bill in regards to that. Let me just tell you kind of where I think I would be, and I think where I think some of my colleagues would be over there that I've heard from.
Thank you.
One is that, well, actually, before I go there, let me talk about the challenges of point of sale.
Okay.
You know, the difference for the BOE to collect from, I don't know, let's pick a number, distributors, if let's say there's 50 of them, who knows what the number is going to be, 50 of them, is a lot easier than thousands and thousands of retailers.
Understood.
So that becomes a bigger chore for us in a challenging way. And on top of that, we already struggle with the amount of cash coming in and the safety, public safety of that aspect. I recently went on a trip where I went to, you know, to a retailer, to a dispensary, you know, watched them do their business, and then took that money on over to the BOE for deposit. Mm-hmm. And this basically takes, right, and again, any given day, not a given day, on a day it's not, we have seen things like, you know, $400,000, $500,000 come in, you know, in duffel bags. Just by sheer numbers, this would crank that up to $1.5 million. So I think that's a big concern I have with just the point of sale issue, both in regards to our ability to actually manage that in terms of trying to collect that in that way, and then also in regards to then just the increased amount of cash that's out there. And again, you got to remember where these are. These dispensaries are in the middle of rows of businesses. These are not secured locations. So we're struggling with that right now, and I can't imagine trying to make these numbers even larger, create that. So that's on the BOE, kind of my opinion in regard to the BOE side of this discussion. The other side of this discussion then is what to do with the money. I have a great deal of problem with trying to then create a tax that then goes into the general fund. I think that I'm an unusual, I'm one of the unusual Republicans that actually supports an excise tax on medical marijuana.
Yeah.
However, I look at the excise tax as a user tax, and that there's a cost then to folks who want to use this product or need this product, and as a result then they need to then help cover the cost of those things. I don't look at the tax as a fundraising effort for the state. And there's two items in here, of which is more than 50% of the cost, because I don't sure what you do with the final 10% anymore. And both the general fund and going to Parks and Rec, are basically just general fund issues. It become then fundraising for state programs that have nothing to do with the issue of the cannabis. I think that's for me a hurdle that I think I would have, and I think many of my colleagues would have, or my colleagues who are willing to at least look at this would have. In regards to those issues. I am concerned about the total amount. I'm interested to see how did you guys establish what the sweet spot was?
Mostly just conversations with folks in other states, and during the last year while we're going through the regulation, we've always made it clear that the taxation is our next step in this process. If we got regulation, and asking folks, where do you see it? Mostly the retailers, some of the cultivators, people in the industry.
I can tell you, I've never talked to a cultivator out there or who would have said 30% is a reasonable issue.
I will say that they.
And I've talked to them. That's not the number.
They don't want any tax.
That's the number in their. That's not the number in their head.
Before they were regulated, they were more willing to talk about that because it's sort of part of the system. Now that the regulation is there and there's a lot more,
No, I've been talking to them since then. I've been talking to them through the regulation, and that's way beyond what they.
Okay, understood.
So anyhow, those would be my observations, and I'm doubly concerned that actually we would actually see, and I don't know where we would do this, where we actually create two excise programs or costs on the same product. Because at least what I'm hearing you say is you're okay with the wood bill and you're okay with this bill, and now you've got excise tax being applied in the wood bill in regards to the distributor, and now you got it at the retailer. I don't know what else and where else we do that, and that sounds like a really expensive process when you're collecting an excise tax in two different places.
I guess tobacco would be an
I
example?
think we do.
The
No, we
retail
only
side?
excise taxes.
Not exactly an excise tax, I guess.
We
but
do
it's
an
a
excise
collection.
tax, and then we do a sales tax.
A sales tax, yeah.
But we don't do two different excises tax.
Understood. Do you mind if I just quickly address
Yeah,
two
right,
of
sure.
the points? So with regard to the amount of cash coming into the BOE, completely, it's a huge issue. And honestly, it probably accounts for a huge percentage of the crime in our district, and we would love to find a solution to that. Whether you collect...
You do agree that this could create a bigger problem?
Well, my next comment was that no matter where you collect this tax, and it's going to be a problem for the BOE to take it, whether you collect it, bringing the cash to the BOE, the cash is going to come to the BOE from the distributor or from the retailer. I do understand the added disadvantage from the numerous retailers doing it and where they are, but unfortunately for the BOE, the cash is the same. It's still coming to you guys, whether it's from the distributor or from the retailer.
Let me just clarify, though. You're right in terms of the cash coming in, but if it's fewer places, it's easier for us to make arrangements.
Yes, I totally.
So if it's a and my understanding would, I don't think you'll find these distributors in strip malls. And so they would be in by their nature more secured ability to deal with issues. So I think that's where the difference would be.
I take your points very seriously. The last thing is that, in answer to you, my boss comes from a city council member. I was a mayor and city council member for 8 years and worked on, he was a member of the Board of Supervisors. We would love to 100% of this money going back to local communities. The extra 10% that you talked about that's going to drug and alcohol is now going directly to cities and counties, doesn't pass through the state, doesn't have any money going through to the state portion of it. The 30% is not our preference, but I believe the administration has made it relatively clear to my boss that there's going to have to be a part of it that goes to the general fund. But it definitely isn't. But I certainly take your point that that's not where we would necessarily like it. Going back to the local communities.
The administration has asked for a portion to go to the general fund?
Well, in our discussions last year during the regulation aspect of this, they made it clear that a tax, that they would be, at that point, in our room, supportive of a tax, but would want to see it coming to the general fund. And I certainly would want, we've made it very clear that we wouldn't support a tax that 100% goes to the general fund. We like the way this lays out. Money is going back to the local communities better than the leading initiative, certainly, and maybe we can still improve upon it.
Remind me under the current regulation, too, what the local abilities and the local communities are to impose their own.
They are able, under the Regulation Act and Senator McGuire's bill, they are able to put a cultivation tax by a vote of the the voters in the district, or a sales tax if they want to.
So again, if the sweet spot is 30%, that doesn't count what a local would.
Oh, no, it does. So if you take 15%, you take Jim Wood's tax, you take the sales tax, and then a local tax. I mean, we're counting that as at hitting 35%, but also counting on a price reduction. And again, if the price reduction doesn't happen, or if it doesn't, that's where we're willing to be certainly lowering our 15%, if that's the case. Thank you, sir. I really appreciate the comments.
Ms. Harkey.
Okay, I'll take kind of the reverse here. People in my district, are not really hot on this, but they want legalization. They think it's great. They're not really happy with the cultivation, manufacturing aspect. We're kind of being flooded by large participants buying up space in communities that have basically ordinances prohibiting. So we'll see what will happen with that, because, my concern is that there'll be initiatives run to oust the current city council and put in who they want,
Understood.
I mean, I think that's where this is going. So my big concern, quite honestly, is that people think there's going to be money to the general fund. That's why they're voting for this. It's going to be cash coming to the state of California. And so if there's not money going to the general fund, people are going to be very dismayed, because when I tell them it's not going to the general fund, the Parker initiative is not, I don't see general fund funding there. They're go, what? We didn't know that. Nobody seems to know that.
Yeah.
So I'm trying to educate, and so I would be supportive of a general fund component, because I think we're going to need it. Our general fund is primarily Health and Human Services, education, and there's some public safety funding that I know we're going to need. I would like to see more public safety funding, specifically whether you have the industry or you don't, so that you can protect your locals from cross-border trade. I mean, in suburban areas, there's no big delineation between what constitutes Lake Forest, El Toro, Irvine, and so if one city wants the trade, the other city doesn't want the trade. They need just as much public safety enforcement as those who don't have. So I'm very concerned that I want to see public safety funding, because I think it's going to be really important. We're also Southern California. I have Orange, Riverside, San Diego, Imperial counties, bottom portion of San Bernardino. We are the border state.
Yeah.
So whatever comes across the border, whatever we have to deal with, we have the cartels, we are going to need some public safety funding, or we're going to have things really blow up down there. And I can't seem to get anyone to quantify exactly what we'll need. I think there's so many agencies kind of involved. And there's pressure, of course, from the administration and others. It's just like they're not really good at quantifying exactly what we'll need. But we had 3 inmates escape from jail in Santa Ana in Orange County, and they took a dispensary owner who was not willing to buy their illegal, that was trying to run a legal operation in Santa Ana. They took him out to the desert and provided him with a blowtorch, and then cut off parts of his body and left him to die. That's their calling card. This is not unusual, okay? This happens. And everybody that's getting involved in trying to do their little legitimate business is running into a huge issue with public safety. If I talk to my sheriffs, I talk to my local police, Border Patrol, anybody, they all will acknowledge this is a huge problem, but there's no coordinated effort to really try to deal with it from a Southern California perspective. So I think that what all of these bills address, and what I've said a long time, is that they all address Northern California, where it's a little more rural. You've got the national forests and other things that are being, poached upon, and so we're correcting those issues. But in the huge population centers, L.A., Orange County, San Diego, Riverside, San Bernardino, we really are going to need, some public safety assistance down there to be sure that we can keep our people safe, and that if we get flooded by cartels buying up cities and whatnot, that we have some way of, some kind of task force to deal with that. The other thing I would add is that I am hearing, and this only makes sense, that cash payments are coming in as overpayments. So then they would be applying for a refund, which in essence means the Board of Equalization is laundering money for them. Okay, just bring in all your cash, overpay your taxes, apply for a refund, then you have a BOE check to take to the bank to use. So I think we have a lot of issues here until we get the banking situation, but I have been working on it, I am working on it, and I'm trying to find a way that we can do kiosk, off-site locations in secured areas where people can actually bring it, not into my BOE facility where I have 200 staff members in the middle of an office and light industrial area, and a lot of food courts and whatnot, but actually have it maybe off-site. I've talked, where do the casinos, the tribes, do they have secure? Is there availability to bring the cash there? And there's just a lot of issues with this. Something that has a security component that's not with staff, that's not on a location where, you're going to have to think to call and have armed guards and whatnot. Because eventually, if this becomes a regular practice, we are going to have people scoping out the BOE facilities to figure out when the cash drops are, and we're going to have some real public safety issues. So I don't want to be in those buildings, and I'm sure nobody in here really wants to be when that stuff is going on. So I think for the heavily populated areas, we have to be very, very careful how we handle this. And so I'd appreciate whatever help you could provide. I think the train's rolling, but I'm very concerned with public safety. And right now, my district is not really taking cash.
Two quick answers real quickly.
Sure.
30% of everything that comes in on the MVT tax goes to public safety, fire districts, local zoning agencies, communities, goes directly back in the form of grants.
Okay, does it go to the counties, or does it go to the fund and then allocated by grant?
It's allocated by grant, and I'll tell you why, is because the police chiefs and the deputy sheriffs have said they don't want a direct allocation to the cities and counties because they don't want, there's a large portion of them that do not want to have marijuana money coming into their departments.
See, this is what I'm dealing with. They don't want
and if you and Mr. Runner could work out the
and
whole
that's why I
general fund
can't seem
thing.
to get a quantification, because they're going to need the backup support, and I understand they don't want it, because they really aren't supportive of the legislation or the bills. So, but the issue that I have is that if it's only by grant, it's only by grant if you allow the trade. And
No, absolutely
so it's not.
No, absolutely not. We don't have anything in our bill that precludes an agency whose jurisdiction has banned marijuana. They can still apply for the grant, absolutely.
Okay,
They
that
still have the
wasn't-
marijuana problem. I mean, everybody has a marijuana issue. All 58 counties and all the cities have a marijuana issue, and we want to make sure we take care of it. In this provision, we're not trying to just take care of the rural community or the cultivator community. I think there's a lot from the local law enforcement, local government perspective around the state that there'll be $50 to $75 million available on a grant basis. We did have a direct allocation at first based on population, but again, the sheriffs and the police departments asked us to change that to a grant. And I think you'll find that even agencies that are reluctant to apply for the grant at first, a year or two down the road will
Their
realize.
neighbor gets a check.
Yeah.
Yes.
Their neighbor gets a check.
Well, I think it's because they don't want to really be supportive of the effort, and I understand that.
totally understand.
And so, to the extent that, we actually give people what they think they're getting, which is general fund funding, they believe this is going to help the state of California. So what I'm seeing in a lot of the planning is really that just funds a bureaucracy that's going to oversee the trade. And I would like to be sure that we do have some general fund funding out of this, and that we have sufficient amounts to go to public safety, because we're going to need it statewide and for a lot of agencies.
Agree with you. I think we've taken care of that. We're open to other language, but the other thing I would offer is that if there's a way in this legislation that we can help the BOE create these collection points with extra funding or specific allocation, I think my boss would be okay with that too. Obviously, we have a lot of BOE offices in our district, and if there's a way to make sure that there's extra protection until the banking situation is solved, we would be open to that.
Well, I'm just saying, I think geographically, there's different needs in different communities. I've got 4 counties that are heavily populated.
Yeah,
It's
so
a
if
lot different than the Golden Triangle or the Emerald Triangle, and then all of the rural counties. Like,
But if these-
Mr. Runner has 30 counties, but we both got 9.5 million people. So what I'm saying is that, geographically, and I would love to have you down, come visit my cities, visit my BOE offices, understand the issues we're dealing with, go to the border with me, review what we've got as public safety issues, and then I would just, because I want to stay engaged on this issue, because otherwise they have no voice in Southern California.
If we can allocate some dollars specifically for taking care of the security concerns around the cash in this bill, it seems like a good idea, and I apologize, I hadn't thought about that in the past, but coming here, bringing it up, it does seem like it makes a lot of sense.
It's huge. It will
Yeah.
be.
Okay.
So,
Hey, thank you.
Thank you very much.
Thank you, Ms. Harkey, and I just want to put it out there, what you said about the offices over-collecting and then sending refunds. As I understood, that is not the case. They're going to refund maybe if the, if the difference is small. But one of the issues I think we should look at is if people want to prepay their sales taxes and keep it in the account to get the cash off the street, but be able to use it for future sales taxes, I would be very open to that, but not, obviously prepaying and refunding and getting a check from the state of California so they can put it in the bank. That is, I don't think, what we should be doing, and I see Mr. Gao is here, and I'm sure we're going to take a look at that in all the offices to see whether this is happening or not, but we are looking at other ways to make this process safer in the offices. I know that we either have an RFP out right now, trying to figure out whether there are, cash counters, cash kiosks, something that will make, the cash collection safer in our offices. And stay tuned, I guess, for a future update, and maybe he can do it in the in his update later on if he cares to share with the public, what we're doing around this area. But I'd like to keep moving. Everyone's time is valuable, and Mr. Horton does have some comments. Mr. Horton.
Thank you, Madam Chair. Historically, a marginal increase in sales tax caused a corresponding significant increase in the activity in the underground economy. And so a 30% increase is a windfall to the criminals that are out there operating in the underground economy. And so that's going to be a huge concern for my community, such that we have many of these dispensaries are actually located in Southern California from a numerical perspective. And so therein is where that sort of challenge is created. I agree with Member Harkey that possibly a thought process that takes a look at backfilling the general fund for the mitigation of the negative impact on the various different communities and trying to compute what that might be. The other challenge that we've experienced is with the tobacco industry. When we first began to deal with just the counterfeiting in the tobacco industry, which is a far more regulated industry, is regulated on the federal level, the state level, and to some degree internationally as well. And the uniqueness about tobacco is the fact that the product is not manufactured here in California. So with cannabis, we are one of the main distributors of cannabis throughout the world. And so it creates an inherent challenge for us because the growers can actually sell it directly to the consumers unless there is some regulatory oversight by the taxing agencies. We have no legal authority to deal with that if they're selling it to someone who is subsequently going to resell it. And so it's an exempt sale from our perspective, and which doesn't give us the authority to regulate it and to enforce the law. So even though we have a projection of $251 million, without the staffing and the authority to enforce the law, you're not going to get all that money. Based on our experiences in the tobacco industry, we had a significant non-compliance. The estimates, as I've heard them, in this industry will be somewhere around 60 to 70% non-compliance. If you use the numbers in Los Angeles County alone, we have 135 dispensaries who are licensed, but yet still over 2,000 folks that are operating without a license. So that's a 200% non-compliance that you start out with no real incentive for them to come into compliance, because coming into compliance simply means that you're now tracked by the federal government, you're now tracked by local government, you're tracked by state government, and on top of that, you're paying an additional additional tax, excise, sales tax, local tax, and property taxes and so forth. So all of a sudden, your margin of profit, your cost of operating is somewhere around 50–60% when you add up all the taxes and regulations associated with that, which creates that windfall for the black market or the underground economy. So I would encourage us to take a look at, one, establishing an enforcement task force that can enforce this law, and allocating, I don't know what the percentage was, but if I was being greedy, I'd ask for 30–40% to the Board of Equalization, so that we can hire the staff necessary to enforce the law. Certainly, under a voluntary system, the numbers that we projected as far as our costs, if everyone voluntarily complies, we probably can get there. But our experience in criminal activity, which this is for the most part criminal activities, that we are trying to evolve into a legitimate business. And if you look at the history of alcohol, gambling, and so forth, you see that evolution is almost a 30-year process before you even get to a significant level of self-compliance. So you've got a number of years where you have no compliance at all, you have no regulatory oversight by the entity that is responsible for collecting the tax, and we don't have the staffing necessary to do the job. So our options would be to shift our staff from another industry that we're generating revenue for the state of California into this industry, and we can't afford to do that. So unless the funding comes from somewhere in order to address that concern, this is a nice number, $251 million, and all these numbers are nice numbers, but they're not reality if we can't enforce the law.
Understood, Mr. Horton. I think that the regulation that was put in place last year that comes into 2018 will help this significantly, but I completely agree, and I don't think anybody in this room would disagree, that it's going to take a number of years for everything to kind of work out from a regulatory standpoint. And I do like the idea of providing additional dollars to the BOE to take care of especially the security concerns.
Well, mine is the security concerns, but mine is more the enforcement. This would be investigators that are investigating. This would be prosecutors on the AG side. This would be auditors that are additional auditors that are conducting these audits and so forth. Without all of those staffing components in place, we're just not going to be able to collect the funds. We just can't do it. We currently audit somewhere around 1% of our entire universe, and so this is going to add a significant level of issues for the Board of Equalization just by adding this criminal component to our operation. And so if we only have capacity to audit less than 1% of the existing universe, you add this element to it, we just don't have the capacity in order to be able to address those issues.
We'd be very happy to work with your staff on that. Thank you, sir.
Okay, so thank you, Mr. Lyles. I think you've heard from the board members, and we look forward to following the progress of your bill or Senator McGuire's bill as it moves through the process.
Right.
So thank you very much for coming down today.
I appreciate the constructive criticism and the comments.
Thank you. And we have one last discussion-only bill, and that's Assemblymember Wood's bill, which was mentioned. We don't have any public speakers or staff members, so perhaps you can just read us the analysis, and then we can just maybe close this session and move on to the next committee. So, Ms. Pilstiger.
Yes. AB 2243 by Assemblymember Wood relates to a medical cannabis tax. Existing law imposes this, well, I've already identified the sales tax law a number of times.
Skip that paragraph.
Because medical marijuana is tangible personal property that's not otherwise exempt, it is subject to the sales and use tax. The proposed law would impose upon cultivators a per-ounce medical cannabis tax to be collected by a distributor on the sale of all distributed medical cannabis flowers at $9.25 per ounce, medical cannabis leaves at $2.75 per ounce, and immature medical cannabis plants at $1.25 per ounce. Revenues are allocated as follows: 30% to an unspecified agency for disbursement to local law enforcement-related activities pertaining to illegal cannabis cultivation, 30% to the Natural Resources Agency to fund a competitive grant program for environmental cleanup, restoration, and protection of public and private lands that have been damaged from illegal cannabis cultivation, 30% to the Multi-Agency Task Force, the Department of Fish and Wildlife, and the State Water Resources Control Board to address the environmental impacts of cannabis cultivation on public and private lands in California and on other state enforcement-related activities from illegal cannabis cultivation, and 10% to the Bureau of Medical Marijuana Regulation and other state agencies or departments that the Bureau determines appropriate to conduct ongoing studies of areas that may create challenges to compliance with the Medical Marijuana Regulation and Safety Act. Assuming 100% compliance, annual revenues are estimated to be about $77 million, and I just issue another qualifier that 100% compliance is not the likely compliance rate. The cost impact is pending. However, a similar measure, AB 2243 from last year, as amended in August, had the following estimates. So $705,000 for fiscal year 15-16, $3.9 million for fiscal year 16-17, $3.6 million for 17-18, and $3.7 million for 2018-19 and ongoing.
So I think we have similar concerns, and we look forward to also the progress of this bill. Both bills will require two-thirds vote of the legislature, and I know there's probably going to be many amendments as it goes through the process, so perhaps we can have Assemblymember Wood and Senator McGuire come back at a later time as the bill is moving down the process. So I really want to thank Ms. Peel-Sticker for your good work. It's not easy following all these bills, and I also want to thank Tim Moreland, my legislative staff, for also working hard on this committee and working with members of the legislature and their committee consultants. So thank you very much. This concludes the meeting of the Legislative Committee. Ms. Richmond, will you please introduce the next committee, or do you want to take a 5-minute break, members?
5 minutes.
Okay. If we can just take a 5-minute break. And then we will be back to continue the next committee, which is the Customer Service and Administrative Efficiency Committee. our meeting today. If we could call all of the interested parties back to the boardroom. Okay, Ms. Richmond, please announce the next item.
Our next committee on today's agenda is the Customer Service and Administrative Efficiency Committee. Mr. Runner is the chair of that committee.
Thank
Mr.
you, and
Runner.
we'll call this committee meeting to order. And we have a annual report from the Customer Service Center accomplishments for 2015.
Good morning, everyone.
Morning.
Committee Chair Runner and Madam Chair Ma, members of the board, Todd Gelman, Taxpayers' Rights Advocate with the State Board of Equalization. For discussion by the committee this morning is the Board of Equalization's External Affairs Department Accomplishment Report for calendar year 2015. Next to me is Mr. Thor Dunn, Manager of the Customer Call Center, who will go over the report in more detail. Mr. Dunn?
Thank you. Good morning, Committee Chair Runner and distinguished members. Today I have the honor of presenting the Customer Service Center's 2015 Accomplishment Report. The Customer Service Center is the call center for the Board of Equalization, where we answer the calls received on the BOE's toll-free 800 number. While there is a considerable amount of information on this report, I will keep this brief and just point out highlights on each page and then answer any questions that you might have. On page 1, you will notice that the calls from 2013 to 2015 have gone down. There are many factors that contribute.
Do you have a PowerPoint?
Yeah.
No, we provided the.
Not provided.
We do have it on the pan. We did provide the.
Get this.
We have it in our book. Do you have it?
Okay.
I'm sorry.
Should be able to see it there.
I know when he's saying like page 1.
Oh.
I do have additional copies if anybody needs those.
No, I have it. I'm just saying that
Okay.
you're talking about it.
Oh, it's not, you. Are you saying it's, so we don't have it for presentation?
No, it's not.
Okay.
I got it.
We'll make note of that for
problem.
next
That's a
time if
problem.
we have an item like this to make
That
sure
would be
it's on the
good.
video. So.
Okay.
That would be good.
Next year.
In 2013 and 15, there are many factors that contribute to a change, which was the decrease in calls. Some of these factors include customers' familiarity with our services and changes to the Board of Equalization's made for the improvement on the functionality of online services. Next, I would like to point out the 50% reduction in abandoned calls. This reduction improves our customers' ability to receive assistance that they need to comply voluntarily when they need that assistance. On page 2, the average call wait time is at an acceptable 1 minute and 17 seconds. Below this information, the graphs show calls handled by the Customer Service Center and the calls transferred to other sections. Consistently, the Customer Service Center is able to answer 75% of those calls without the need to transfer them. If we move on to page 3, this page shows a breakdown on the type of calls being received. Looking at this information, you will notice that the online registration and return assistance make up 38% of the calls being received. On page 4, we take a look at the emails received. In 2015, over 16,000 emails were received, and 75% of those were answered by the Customer Service Center, with the remaining 25% being forwarded to other sections for processing. Finally, on pages 5 and 6, you are shown the information on the Customer Service Center's Account Maintenance Cleanup Pilot Program. This pilot was started to address the outdated account holder information, which creates returned mail and emails. In 2015, staff working on the pilot program made more than 76,000 updates to both account and client information. These changes are essential with ensuring our customers are receiving the information they need to comply voluntarily. This concludes my brief review of the accomplishment report. However, I would like to add that in the next couple of months, the call center is starting a voluntary customer service survey. Using the information from the survey, we are going to continue to improve upon our customer service experience. I would like to thank you for your time, and before I leave, are there any questions I can answer for you?
Quickly on that survey, That was established in such a way that helped you make sure you had good, clear data, right?
Correct. What we're looking for is not only to identify if the customer received the information that they needed, but in a way that was acceptable to them. And also, we give the customer to leave a brief message to provide additional detail just in case that information is needed as well.
Can I ask, I'm sorry, so when you're going to do a survey, how are you going to survey folks after they hang up or after they get their calls answered?
Well, exactly. So what's going to happen is they'll get the option to participate in the survey when they first call. If they choose to participate at the end of their call, it'll be provided to them.
And will you have a website in case people would like to log on to a website and provide comments after?
Well, we do have the Board of Equalization's email, and we do have a survey on the Board of Equalization's website as well.
Okay.
Other questions?
Yes. What are some of the typical questions you're getting on your customer calls?
A lot of the questions pertain to online services, assistance with registration, and then during peak periods of January, July, April, and October, it's mostly assistance with filing returns. With the call center, we're a little different than some taxing agencies. We'll actually walk a customer through the complete return.
Member Horton?
Thank you, Chairman. This is a good thing, actually. I wanted to commend you on the training as well as the work that you're doing. But I also wanted to ask, is it possible that our program techs and tax technicians can receive the same level of training? I visited several of our offices, and the program techs have indicated that the individuals who move from the call center into the compliance department are better trained because you guys are doing such an exceptional job in training them, rightfully so. I mean, conceptually, the call center is not only does it serve the people of the state of California in answering their questions and helping to deal with constituent issues, it also serves as a training ground for many of our employees that we're recruiting and bringing into the Board of Equalization, and you're doing an exceptional job. So I'd like to see that training to be available to our TT1s and program technicians. Up to 3, I think, would be the level, but we can figure that out.
That's a good thought, and we'll follow up with from the committee in regards to how and with the different parts and departments that we would need to coordinate with that. But I think it's a good idea. Obviously, you become an expert pretty quick when you're just going from one question to after another and answering the question. Right. But at the same time, we train them in such a way that they're prepared for that. And if we can do that better for those in our district offices, that's a great idea.
Thank you.
Well, thank you. And we'll definitely work with the Customer Service Committee to see what we can do to expand that training.
Okay. Thank you very much. That concludes our report and our committee.
Thank you, members.
We're adjourned.
Okay, thank you. Ms. Richmond, will you please introduce the next committee?
The next committee is the Business Taxes Committee. Ms. Harkey is the chair of that committee. Ms. Harkey.
Thank you, Ms. Richmond. Members, the Business Taxes Committee meeting is called to order. Ms. Bueller, will you please introduce the first item?
Good morning. I am Suzanne Bueller with the Business Tax and Fee Department. We have 3 agenda items for your consideration today. We will take each agenda item and their respective action items separately before moving to the next. With me for agenda item 1 is Mr. Scott Claremont from our legal department. For this item, we have 2 action items. In action item 1, we request your approval and authorization to publish proposed amendments to Sales and Use Tax Regulations 1703, interest and penalties. The proposed amendments clarify the Board of Equalization's longstanding policy of generally not imposing a negligence penalty on a taxpayer's first audit liability. We would be happy to answer any questions you may have on this topic.
Thank you. Members? Is there anyone from the public? There is no one from the public. Okay, members, any discussion? Okay, hearing none. Is there a motion?
Move.
So moved.
Second.
Second by Mr. Runner. Any objection? No? Such will be the order. Thank you.
In
Next
action
item.
item 2, we request your approval of the proposed revisions to Audit Manual Chapter 5, Penalties, to explain the circumstances and provide examples of when a negligence penalty may apply to a taxpayer's first audit liability. Again, we would be happy to answer any questions you may have on this topic.
Are there any members of the public to speak? Seeing none. Members, any discussion? No? Okay, do I have a
Move to adopt.
motion? Moved by Mr. Runner, second by Ms. Ma. No objection, such will be the order.
Joining me for Agenda Item 2 is Ms. Christine Bisada from our Legal Department. Staff requests your approval and authorization to publish proposed amendments to Sales and Use Tax Regulation 1702.5, Responsible Person Liability. The proposed amendments clarify definitions, explain the applicable standard of proof, and add a rebuttable presumption of when there is no personal liability for certain types of persons. We do not have any speakers on this item, so we'd be happy to answer any questions you may have on this topic.
Thank you. Members, any questions, comments?
Move to adopt.
Moved by Senator Runner,
Second.
second by Ms. Stowers. No objections, such will be the order. Thank you.
So with me for Agenda Item 3 are Mr. Richard Parrott from the Business Tax and Fee Department and Mr. Stephen Smith from the Legal Department. Staff requests your approval and authorization to publish proposed cigarette and tobacco products tax regulation 4001, retail stock. We ask that the board approve either Alternative 1, staff's recommendation, which defines and clarifies the term retail stock and explains when inventory is considered held in retail stock. It provides examples to assist taxpayers in the application of tax, and it also provides a presumption of distribution of cigarette and tobacco products no longer in the distributor's possession and examples of evidence of how distributors can overcome this presumption.
Thank you. We
Or-
have, go ahead, I'm sorry.
I'm sorry. Or you may approve Alternative 2, language proposed by SEIU. SEIU's proposal requires that untaxed cigarette and tobacco products must be segregated and securely stored away from the area where retail sales are made. Secure is defined as behind a locked door. It also includes a provision that a person who is both a licensed retailer and a licensed distributor and makes substantially all sales as retail sales holds all inventory for sale in the retail location in retail stock. Finally, with regard to overcoming the presumption of distribution, SEIU's recommendation requires timely filed police reports and product purchase invoices. We do have speakers on this agenda item, and we'd be happy to answer any questions they may have after their presentation.
Thank you. Would you have a seat? I believe we have Mr. Randall Cheek, Mr. Steve Alare, and Mr. James Demler. Are there any other public speakers? Okay, thank you.
Madam Chair, Randy Cheek with SEIU Local 1000. We represent a lot of the employees with the BUE, including the agents who have to do the inspections and make sure that product is being taxed properly and that there is no illegal operations going on. I brought with me Mr. Stephen Alari, who's one of our agents, who can explain why we feel that having segregated items is important to our agents who are going into the field doing the job. By the way, we want to thank the board for having the meeting. We had a previous meeting. Ms. Harkey's people were there, Mr. Runners was there, Ms. Stowers was there, and we tried to work this all out. We feel that we wanted to go beyond that with this extra step, and I'd like Mr. Alari to explain our reasoning.
Madam Chair, members of the board, my name is Stephen Alari. I am a member of SEIU Local 1000, also president of my DLC down, my district labor council down in Southern California. I've been an investigator with the board for about 11 years in the investigations division. We went to the interested parties meeting, we heard the concerns, met with numerous investigators with experience of doing over at least a couple thousand inspections, if not assisting in even more inspections. We had concerns regarding the Alternative 1, and I want to thank Ms. Stowers for helping really do the foundation and really addressed a lot of the issues. But you're representatives in the field. We're the ones doing the actual inspections, and On behalf of Local 1000 and our President Yvonne Walker, we do support alternative number 2. It creates a bright line. It asks, and it lowers the opportunity for tax evasion. It also, during our inspections, we come in to do the inspection. We believe having the untaxed tobacco product secured separately from the tax-free product will make it a more efficient inspection, a shorter inspection. When we walk in and do our inspection, of course, we identify ourselves. We let the distributor, retailer know what kind of inspection we're going to do, the procedures. When we're able to go into the back rooms, we're going to see if the product is secured, as we are suggesting. This product here is untaxed. We know it's untaxed. We do our inspection invoices. We can verify it. The tax-paid product, it's separate. It makes it a lot easier to do the inspection. If we believe it's the unintended consequences, if alternative 1 is adopted, is that there are stores, not just cigar stores, but there are cigarette stores, liquor stores that have issues that we've had issues with in the past, where if they just pay the $1,000 to get a distributor license, we can go into our inspection and they'll walk into the store and we find a bunch of tobacco back there. They say, oh, that's just our untaxed product. And if it's not segregated, it's hard for us to be able to inventory it and to provide evidence that taxes were paid on it. So it really is important that the product is secured. I want to clarify the door. It could be a locked file cabinet, it could be a locked cabinet that they have the untaxed tobacco stored in. Our cigarette distributors who apply stamps, they're supposed to keep the unstamped cigarettes separate from where the stamps are, so they have to have it secured there. So we just want to be able to do that for tobacco. Tobacco doesn't have tax stamps on it. So to be able to do our jobs, we believe alternative 2 is the best. We initially opposed having any untaxed tobacco in the humidor. In discussion with our president and our representatives, we have concurred that that retailer distributor wants to store untaxed product in the humidor, they're behind a secured door. Now, it could be a door with holes in it. I mean, the full boxes that we're talking about, sealed boxes, can still be behind it. They'll still get the humidor effect. Or you could have the mesh fencing there, still locked, because it's very tempting. People we've talked to, our investigators, as well as other people, you walk into a humidor to buy a cigar you want that Romeo and Juliet, whatever brand it was, it's not there, it's right there on your left on the shelf, as it's an alternative 1, they're just going to take it and sell it. I mean, the customer wants the product, the business owner wants to sell the product, it's sitting there, but it's untaxed. It's very tempting, it's harder for them to justify not selling it to their customer. So we believe our compromise is a good compromise. Also, we asked in our recommendation, our first recommendation back after our interested party meeting was in regards to the evidence to overcome presumption about the tax being paid. We've wanted to ask that the police reports be timely. We do ask that in our proposal because we've had instances where we've had cases where 2-3 months, if not later, all of a sudden the guy's trying to not to pay the tax and he's saying, and we say you need a police report, then he goes and files a police report. So we think it's important that if someone has a theft of tobacco from their business, that they should have to report it timely to the police department, so they have a timely police report. We had also initially asked for the insurance claim and the insurance reimbursement be required. In talking with staff, they informed us during the first interested party meeting, which we were not at, that issue was addressed, and I guess some of the stores self-insure. So we withdrew our request that they be required for insurance claim or insurance reimbursement. But we also think it's important that the cigarette and tobacco invoices be required. I know it's existing regulations that they're supposed to keep them, but a lot of times we hear from these people who supposedly had thefts, they took my paperwork too. I mean, I've personally been doing an inspection where the guys, they took my stuff, and I don't have any paperwork. They took it all. They took all my invoices. I mean, so I believe it's important that you have the invoices to prove what you bought to be able, and so. And an alternative 1, like I said, the concern was the humidor. If it's right there, it's very easy for the customer to want to take it or the clerk to want to sell it. And then also, I mentioned unintended consequences. Regarding any sale, I appreciate the language written that if there's any sale, that if a retail distributor, it's considered that they are retailers, then it's all retail stock, you owe the tax on it. But in the provision number 1, it did say does not make any sales for resale to any of the licensees. During our interested parties meeting, that issue came up. And one of the board member representatives said, well, so if they make one sale, then they're exempt from that provision. So we were trying to figure out what is a reasonable number, and that's where we came up with 20%. It's reasonable for our investigators to use because we used the year period because people have filed their tax returns, their sales and use tax returns, so we know what number their sales are. So if it's reported they sold $30,000 in a 12-month period, we could easily figure out what 80% of that is for their number for if they're under the requirement that everything is tax paid or not tax paid. We thought it was a reasonable number, and we ask for your support for alternative number 2, and be glad to answer any questions.
Madam Chair, members, thank you for this opportunity. My name is James Dumler, by the way, from McClellan Davis. I'm going to attempt to go off script and without making a fool out of myself and provide you guys with some examples of what we've seen. I can't speak to the inspection side, but what prompted our involvement is a case very similar to the one that was brought before you that prompted this process, where you had a distributor retailer that was maintaining both wholesale and retail stock in the same humidor, and we were left working with the staff with equal confusion on both sides because there was no guidance provided as to how do we account for this inventory within an audit context. It was ending inventory that we were trying to quantify. Had this language been made available, it would have been, I don't want to say no questions would have existed, but there would have been far fewer questions, and at least some guidance that we could have pointed to and relied upon to answer the questions. The other taxpayer issue that comes to mind has to deal with unexplained disappearance, which is, I believe, subdivision 2 of the staff's proposed language, where you have a taxpayer that this was a theft of inventory by an employee, and there's the presumption of distribution and taxability that we were trying to overcome and working with staff, and there were no examples that we could rely on or point to and say a police report or an insurance claim or video surveillance. And had this language been available at that time, it really would have been a non-issue. It would have been easily addressed by us and the staff, and because of that, we're here to support staff's current proposed language, which now includes Ms. Stauer's well-placed suggestions, because it will provide beneficial language for both taxpayers and staff when we're dealing with these issues. Thank you.
Thank you. Yes, Ms. Stowers.
Thank you, everyone. I appreciate staff recommendation language, which does include a lot of the comments that I made. I'm looking at SEIU's alternative 2. I probably will work backwards. You have a comment regarding the police report having been a timely report. I do agree with that because this is just a list of evidence that they can present. It's not, they don't have to present each and every one of these, but if a taxpayer is going to say, I'm going to provide you with the police report, one would hope that a report was filed at the time of the event. So I would suggest that we add that into alternative number 1. I think that's an easy fix. As far as the purchase invoice, I understand that is a requirement within the statute that a distributor is required to maintain the purchase invoice for a certain amount of years. So to put it in here again as required, it may be redundant, but I think even in my suggested language, I have some items in here that are redundant. It's more of a gentle reminder to the taxpayer of their obligation. So I would suggest that we put the required purchase, have the language in there that the purchase invoice are required. As far as the locked area behind a locked door, I mean, that's the language just in here. And I will admit that I thought that was a good way of separating the two. But when you consider some of the businesses, they may not have a locked door. I'm imagining a small retailer, distributor, and they basically have a one room, and they're separating their inventory with file cabinets or petitions, so they don't have that door available to them, and to require them to go out and ask the landlord to build in the door so they can have it in the locked door, that's an excessive burden on a business, or normally a small business, that I don't think we should require. I am open to some cleanup language saying a file cabinet. I kind of thought that the alternative one addressed it when it says storeroom, closets, back office, and safes.
Safes or file cabinets.
Yeah, so, safes or file cabinets would kind of address that.
Yeah.
So those are all my thoughts. I lean towards alternative one with a little cleanup language there.
Thank you. Any other comments?
Yeah, just a quick question.
Yes.
The issue of timely of a police report, that makes sense, but in reality, don't law enforcement already require some kind of timely report?
Sir, I've talked to some of our felony investigators, and they've had people go back 2-3 months later and say, "Oh, I need a secondary report," and then they'll create a secondary report for them, and they'll give them a report.
So they'll actually get sheriff's departments that'll come and do a report that's 3 months late?
Yes, they have people 2-3 months later. They write a report for them.
Must be a sheriff's department with a lot of extra people.
They've come to me and told me. I asked around about that because.
And I'm sorry, did we have a definition for what timely was then?
We don't.
I'm not sure if you want to set a date on there. I'm not sure. But if we have timely and or other documents for sales and use tax, I'm not sure.
How does that work that they can call someone in 3 months later and just not doing an investigation or just taking the word of, a retailer saying, yeah, just write it up like this is what happened, and they come in and they write it? I mean, aren't they supposed to do some sort of due diligence? If there's a robbery, they're supposed to come in and, actually look at the evidence and ascertain whether there was a robbery, doors being jammed open, windows being broken, something, versus coming back 3 months later and going, okay, I'll write you a report. I mean, does that really happen?
Yes, ma'am. I've been told by one of our felony investigators, yes, it does happen, that they go and get a police report after they've been told you need to have a police report. They just go to their police department and say, hey, I was broken into this day. I need a report that this happened. And they'll create it. And they've created it in the past for us.
Thank you, Madam Chair. Because of staffing issues, you can actually, they don't come out. You can walk into the police department. Many people have accidents and police never show up to take the report, but they're asked by their insurance agent to go into the police department and report it. Police do not ascertain whether or not anything happened. They just say, this is what we were told, and when they're there, they will say, this is what we observed, but it's difficult to say what they observed in this case. It does happen. It's been, and happens on the audit level as well. When we're going out doing audits, folks come in with police reports in order to increase their percentage allowance for pilferage. Almost 2 years later, they'll go back and we actually accept it if there's collaborating evidence to support that something actually happened. If I may, Madam Chair, a couple of questions.
Sure. Thank you.
What's now that Member Stowart has shared her recommended amendments, what would now be the primary difference between option 1 and option 2, from your perspective?
Well, looking at our option 2, I understand the members or representatives' position about, for the purposes of regulations, the secured is defined behind a locked door. I mean, you're correct. It does say secure. Earlier, it says secured storeroom and all that. I mean, if we strike that line, I think that's amenable. The only other concern we have on number 2 is about the humidor, about having a secured area in that humidor. And like I say, we could have examples. Another regulation that we proposed about when we were talking about transfer regulations, they would also have like some examples. So maybe for having the secured in the humidor, have examples behind a locked door with holes or with mesh to make sure it's secured from the public's access to it.
Go ahead.
Madam Chair,
Yes.
what's the department's view of secure facilities or secured somewhere?
Well, we believe that in the staff's recommended alternative with regard to humidors, that we've created a clear distinction that within that humidor, separated and segregated from retail stock, but the tipping point is that it's still in the original manufacturer packaging with the seal unbroken. We felt that created a bright line of being able to differentiate anything that's outside of that original manufacturer packaging and not wrapped would be the non-retail stock.
Mr. Cheeks?
I think that creates the problem of, if you've been in some of these humidors, you realize that they're unmanned, and people can go in, a customer can go into a humidor, see that his brand of cigar is not there, look over to the side and see that, oh yeah, there it is. It may be sealed, but he doesn't realize that that's not taxed. He breaks that seal and buys that cigar. You're now losing revenue because he's gone over to an area that's supposed to be separate and untaxed, but he sees the cigar he wants because there's nobody in those humidors most of the time. I mean, I've seen some of these humidors, and they do not put a manned person in that humidor to make sure that a customer cannot buy an untaxed product. And that's part of our concern.
Okay,
And the tax is 28% on these cigars.
To the issue of insurance, even when they self-insure, they ought to be able to sort of document the fact that they're self-insured, and they ought to be able to support that somehow. And even so, if they can't, maybe an exclusion for those who are self-insured. Being self-insured should not be reduced to, well, I decided not to get insurance and pay for it if something went wrong. But the reality is this is just one of many things that they can provide to support their position. So having it listed is not all-inclusive, and that it's mandatory that this item be there. A larger concern for me, though, is this sort of reminds me of this series, The Boss, where the executive goes down and works in the warehouse and realizes that there was a whole different world when you're actually on the front line trying to enforce these laws. And so I would have a tendency to sort of rely on the folks that are enforcing the laws, that are to some degree putting their lives on the line and trying to protect the revenue of the state of California to assure that everyone's in compliance and level the playing field for all of those who are in compliance. And so having representation from both elements of our agency not in concurrence or even having SEI even having to come to share what the concerns are of the folks of the front line. If this is occurring in other areas of our organization, it may be part of the inherent challenge of the distinction between Sacramento and the district office and what actually happens in the district office and being able to adjust those concerns. So specifically, we ought to, maybe we can come up with a way of defining secured in a way that the folks who have to enforce the law feel that is sufficient. And substantially all, I believe, was another concern. Any views on that?
I'd like to make a comment, and Richard, maybe you can follow up with this. Investigations is not here, and I appreciate SEIU, and that's why we brought this back, and we got a lot of amendments that took care of a lot of their concerns. But one of the things that I'd like to emphasize is that we're saying that if somebody takes a cigar, then it's lost revenues. And isn't that actually reported the month of distribution? So it's not lost, it's just then that becomes part of the retail stock.
Yes, Madam Chair, yes,
Okay.
it is.
So I just want to clarify, we're trying to work with this such that it helps the small guys as well as the large distributors, and that, it resulted from a case that we had, and we have tried to work with this really carefully. And I would very much support the purchase invoice being, delineated one more time in here, and timely police reports, I think that maybe one of the things, it says that this examples of evidence that may overcome the presumption include but are not limited to the following. So it's an example, a police report, you could say it probably be timely, but if it wasn't available, then all these other things, insurance claim, reimbursements, other things would, are these aren't all-inclusive, you have to have all of them, is that correct?
Correct. And we have it listed as not all-inclusive, and it would be a preponderance of those items that are submitted in the event of a disappearance.
Right, so I would support that, because I do support that. I think that the bigger question is if they're sealed in the original packaging, segregated in some fashion, and I would even be able to, we have safe or, examples of these may include but are not limited to, so not limited to storerooms, closets, back offices, and safes. We could add a cabinet to that, whatever would make it easy for you. But if they're clearly up above, beyond reach of anyone, where you would have to, actually access, then that might be another area that you could store as safe, as long as it's in the original packaging. And I think Ms. Stowers tried to work with this because she was the one that brought it, up to our attention that we need to take this back. So do you have any other comments, Mr. Parrott?
We could look at the, Ms. Harkey, what you were just saying, the language that you're talking about, and I believe SEIU's concerns is that we don't have it anywhere in reference to the humidors, so we could look at that as well. I think that's...
What are we looking at, though?
Well,
because we've examined this thoroughly. What
Yes.
would we like to see? And let's kind of make the decision today if we could.
In two, where we talk about secured areas in walk-in humidors, and when we get down to A, this, correct, you could correct me if I'm wrong, the secured areas are talking about areas that are not in the humidor. So I believe SEIU's concerns is that we also add some sort of language about some sort of secure area within the humidor, although we say segregated and separated from retail stock. And
Segregated and separated from retail stock in the original packaging,
Right.
unbroken.
Mm-hmm.
And I think that for a small area, and if in fact, let's say, in the worst case, somebody would get to that. What I've heard is usually it's up above. It's stored up above,
Right.
because there's not a lot of room in these places. So what they're selling is on the shelves. And at that time, it becomes retail stock
Right.
once it moves from the up above to the below. If it's, if we could just add something maybe just out of reach of, I don't know. I'm trying to work with this here. I think we've got it pretty well sewn up where we are. I would like to go with the language number 1 with those few amendments. Unless it's going to present a huge problem. Because I think if we further refine and define, we're going to be back here again trying to figure out what we're doing with these smaller operators.
Madam Chair, just a question, are you also including in your recommendation, the untaxed tobacco must be segregated and secured separately from the tax-paid product away from the retail area, so that the retail product and the the tax-paid product and the untax-paid product is segregated? Because that's one of the big keys, is that we come to the inspection, and as I mentioned, unintended consequences. Some of these cigarette stores, they have like 5 line deep all the time, businesses coming in, and we found cases of Swisher Sweets or Black and Milds. I mean, not to find cigars with, even the humidor thing. And that's where, those are the big items where it's hard to track. Those move quickly, and if we come into inspection and he has the distributor license and a retail license, he can say, oh, that's my untaxed product. I have a distributor's license. We have no way of tracking.
But we have here, it has to be segregated away from the retail stock, and that it needs to be in original packaging.
But
Is that what you're finding?
we're also asking that it be separated from tax-paid tobacco products, because some tobacco, some of these boxes are little boxes of Swisher Sweets, and then they come in the cases.
I
So it's
think
not
that
just-
there again, we're getting back to the problem where we've got with the small entity. If you're large enough to put things in a locked area and put them away, but what we're trying to do is facilitate the single seller of product that this cash flow is really very important to them to stay in business and to keep, keep their sales going and moving. And so, do you have any suggestion, Mr. Parrott? I think we beat this around a lot.
Yes,
and I'm trying to.
I believe we're in a good place we believe we've created a clear line here to differentiate. And we also are talking about in these businesses that are not making any sales for resale, but they do hold a distributor's and a retailer's license. Our language is clear that all of the product there is retail stock. It's intended for retail stock. They are not typically a distributor in the sense of they're selling to other wholesalers. So we've created that clear line in our language as well.
Madam Chair.
Yes, sir.
The word secure itself may be the problem that we're facing here. Home Depot has solved this problem. They just put it behind a wire mesh. The problem is the customer having access to it, and the customer having to break the wire mesh and whatever little lock they may have on there, and it's a nominal cost of securing it. Would that work?
Yes. Yes.
Okay. So the issue of when a person is both a licensed retailer and a licensed distributor, one of your requests was that the term substantially all means all retail sales. Well, how does the department differ from that?
Ours says a person who's a distributor and a retailer who only makes retail sales. Everything in there is intended for retail stock.
How do you define substantially all?
I don't believe we have substantially all.
You said only, which is all.
We have they only make retail sales, meaning they don't make sales for resale. We felt that having a 20% requirement actually makes it more complicated to differentiate if they only make retail sales at that business location but hold both the distributor's and retailer's license, all of the product at that location is intended for retail stock.
That seems reasonable. And the burden of distinguishing that or even having to go in and verify that may be a little complicated. But SEIU?
Yeah, the concern, the word any, for the bad dealers we're talking about, those folks, not the good retailer distributors. All they do is make one sale to their buddy down the street. Say, I'm selling you one distributor. Okay, I'll sell you, 5 boxes of this. Now I'm exempt because I made a sale. And that was brought up by one of the board member staffs at the interested parties meeting. Yeah. And that's where we're trying to figure out what kind of number could we do that would be reasonable.
Yeah.
So maybe it's 50%. Some, we'll make a bigger number. But it's a number that they have to really be a distributor to be able to use that exemption. It's not retail stock.
Yeah, that's a problem that would be indicative of someone who's trying to circumvent the laws. So
we always have tax cheats, though, but I think we get them usually during the audit proceedings. Or, I think we have secure lines in place to, if in fact you go in and you find that something's untoward, then call in audit staff. I don't think all of that needs to happen in this piece of legislation. What we're trying to do is facilitate something, and I think we've gone a long way to meeting SEIU concerns in the language and ensuring that we have something that's sealed, not available, has an audit trail. I mean, if you're trying to seize product, then that's a different problem. Then you've got an illegal operator. But if you're trying to just verify that, the law is being followed, I think we've got a lot of it in here, and we've worked a long time. I appreciate your cooperation with what we've done thus far so that we could move this along. Because I think you've added a lot of good salient points. Yes, Mr.
I think when we get to these issues, I'm always trying to weigh the cost versus the benefit. And again, as you said, there are a lot of fine taxpayers out there who are doing it correctly, and then I worry about then what else we put them through in order to catch the ones that aren't doing it right. Because that's what it comes down to. Everybody has to comply with this. And so then we've got folks that are having to redo everything or redo some aspect of their storage, whatever they've done, even though they've always done everything correct, their inspections are always right and whatnot, but yet we're saying, hey, because of these other folks over here, we need you to change what you do. And I'm not right now convinced of how big of a problem we're trying to solve. And I think that's part of my issue, and I don't know, I assume that was part of the issues discussions that the staff had at interested parties. I mean, help me get some parameters around this. How big is the problem we're trying to solve? I just asked the staff. Yeah, go ahead.
Yeah, I don't know that was made clear during the meetings. I will say that during these meetings and discussing this language, we were discussing the inspectors are checking for compliance with the Cigarette and Tobacco Products Licensing Act, which is if you are a retailer, you are only in possession of tax-paid product, and if you are a retailer and a distributor, you are allowed to have untaxed product at that location. The instances that we're talking about today are typically, as Ms. Harkey said, would be picked up in an audit or addressed in an audit, not during a typical inspection. That is for compliance with the Licensing Act. And if they're found out of compliance, that product is seized. But I don't know that we have a handle on what percentage of these bad players we're talking about trying to address with that language. I don't know that was ever really made clear.
Yeah, and just to remind the board, remember, in fact, our committee is working on that project that came out of some of the appeals a couple of months ago, where we ended up with folks that were just unclear in regards to what our expectations were, and when we gave them notice and all these other kinds of things, when they got a seller's permit, what they were told, what they weren't told. And so we're trying to actually go through the letters right now.
Trying to make it a little easier.
And trying to figure out how to get them fully informed. And so I'm concerned again that now on top of that to create some other burden. And again, part of the issue is, again, this idea of, I get the fact that we don't want stuff commingled, and I get the fact that that's important. But I think that at that point, I think the separation, trying to create some of those issues and put that expectation and train those folks in regards to what that is I think some important steps that we need to try to see if we're doing that correctly right now.
Madam Chair?
Yes.
I mean, I can share with the board that this started out as a $214 million problem, and it's through the efforts of the investigation team and the experiences that we've been able to significantly reduce it. It's also a condition from a federal level in compliance with the, with the federal laws. And so the more, as we went through the process some years ago, one of the greatest challenges we had was actually, as Mr. Runner articulated, was with the industry saying, well, you're putting this extra burden on us. But as soon as they start to look at the numbers, they realize the value of leveling the playing field for many of these small operators. They can't compete. They can't compete with folks that are not paying their taxes. They can't compete with folks that are shipping the product in and out of the state. It is a huge challenge for them. So for them to put up a wire mesh door and separate it, or for them to have substantially all their retail sales when they have both the license and so forth, I would venture to say, at least from my experience from interacting with them, that's a small price to pay to make sure that it's a level playing field. We're talking about intrusive criminal activity that is putting a lot of these small operators out of business. And to have the enforcement and the investigating unit able to protect them, maybe we should do an analysis, but from I think I've probably spoken to at least 2,000 or 3,000 of them, and they're all glad to see the investigations going on. It's being brought under control. But I agree, it shouldn't be the door, a whole door, well, a wire mesh like Home Depot has for paint, well, that's kind of reasonable. Substantially all, well, that's kind of consistent with the law. And so one might question whether we're varying from the existing law or the intent of the law. And as the author of the bill, I can tell you that the intent was to make sure that we had an element of control where you couldn't have those situations where they could sell to one person and then all of a sudden they qualify, which creates an investigation nightmare. So, I think those are nominal requests, and would suggest we incorporate that into the, as recommended.
Ms. Stowers?
Yes, just on the substantially all. I was at that IP meeting, and I did have the language substantially all. And the question was asked, how would you define it? And I think I quickly came up with 80% just based on prior or existing statutes. And someone did comment that that would be too hard, and that if you just say any, then one sale would do. And they wouldn't be, or if they make one sale, then they get the benefit of this regulation. And for me, to make one sale and get the benefit of this regulation is not what we're trying to do.
And so let's say all.
So I would say we need to put SEIU's language in here regarding substantially all. I mean, we don't want to basically
which
set up a
section?
loophole. I'm at, little b? Subdivision B?
Okay, a person who's both a licensed retailer and a licensed distributor and makes substantially all sales as retail sales.
Substantially.
Makes, okay, so substantially all sales is retail sales.
Meaning basically they got to have 80%, that 80% threshold. Is that what you guys are saying?
Yes, I mean, if they have to make more than 20% of
More than
their
20%
sales.
of their sales
for
for
whole-
retail.
For distribution, as a distributor.
As a distributor, excuse me.
Correct. So you, yes.
Doesn't that create a problem for the guy that really, explain that. What's the pitfall with that? As far as the distribution for the small guy that actually has inventory that's not for sale, but when it moves down and then becomes part of the retail stock.
Yeah, the language that SEIU is proposing really is focused more on, for the small guy who doesn't make any sales for resale, we've said everything, it's clear everything in there is intended for retail stock. So the language that they're talking about is where someone wants to have the benefit of holding, it really comes down to being able to say that's not retail stock, and I believe it really becomes a matter in the case of disappearance of the product, because it's no longer there, and they can claim that that portion was non-retail stock and therefore not subject to the tax in the matter of a disappearance. I believe that's really where it would come into play in here. In a typical everyday setting, like I had said, the inspectors are really looking for compliance with, is it tax-paid product or not? Do you have a distributor's license that allows you to be in possession of untaxed product? So that substantially all.
Yeah, maybe I can provide some perspective. When a distributor/retailer buys tobacco products, they are going to owe tax on everything they purchase. The question is, when does the incidence of tax trigger?
Right.
It triggers the moment they take ownership of it, with one exception, and that exception is if they're holding it for sale to another licensed seller of tobacco. So what we were saying is, if all your sales are to consumers, everything you hold is in retail stock.
Right.
A question came up, so you really owe tax on it immediately. The only delay for paying tax is if you're holding it for sale to another licensed seller of tobacco. Someone said, well, you know, someone who's trying to evade the laws might make one sale to their friend next door, and then they can sell stuff, and when they get caught, they could say, well, it was stolen, and this rule about it being retail stock doesn't kick in because I made this one sale to someone else. So the idea was, well, maybe we could say that if substantially all your sales are retail sales, then the rule's going to be that we're presuming everything you sell is in retail stock. And remember, what staff considered the rule to be from 1997 until the last board hearing was that if it's in a retail store, it's retail stock. So this is...
Right, and we were trying to accommodate the small distributors And that the gentleman that we had here at the board hearing that had his inventory gone, stolen, whatever, and we're trying to assess what amount of that was taxable, and so that's what generated this, is it generated, it really is a kind of an industry-wide concern. And I think Ms. Stowers has done a fabulous job and also explaining that, this further locking and whatnot would be a problem. Now, the substantially all, so our language says a person who is both a licensed retailer and a licensed distributor, but who only makes retail sales to consumers and does not make any sales for resale to other licensees, hold all inventory intended for sale in retail stock. So what we're trying to get at is that one person that cheats, and there again, the crooks are not going to follow our law anyway. The honest guys are going to have more implementation to further qualify and quantify in an audit situation or in an inspection situation as to what they have. And so I think our actually, it's more clear, does not make any sales for resale to other licensees, rather than substantially all. I don't know. I'm trying to figure out what I am actually doing by amending it, who I am hurting in amending. Can you offer some insight, Mr. Demling?
Our only concern would be for the retailer/distributor that falls within the less than 20%, that actually is making valid distributions. 10% of them, I think the case I was speaking of, he had 10% of them. So he or she would not be allowed to keep their wholesale inventory in the retail location if substantially all were to move forward, right? They would have to keep it, as it reads now, it's a consumer holds all inventory intended for sale at the retail location if they don't meet this 80%. So if you have a taxpayer that's making legitimate distributions less than 20%, they're going to have to keep that wholesale inventory at a different location. Otherwise, when the inspector comes in and sees that it's less than 20%, it's going to be picked up as retail inventory and distributed.
No, the difference is that if their inventory is stolen, we're going to find that it was all retail stock and it was all product that had been subject to tax before the theft. But they can keep it in the store, but they have to pay tax on their purchases.
I'm reading SEIU's version. It says sales to customers holds all inventory intended for sale in the retail location in retail stock.
And retail stock is in the store, so
Sure.
So why would you say you can't keep it in the store if it's retail stock?
I guess I'm talking about the wholesale inventory.
Madam Chair.
Yes, Mr. Hort.
I just noticed we have colloquy.
Yeah, we did, but quite honestly, I was enjoying the back and forth because I was getting some information and we were able to hear each other, and I'm sorry, it didn't seem to get out of hand. But what he's saying is that the smaller guy that has like an issue will have, and this is what we're trying to fix. I mean, that's the intent of this. We don't have a problem with the large distributor, and I'm just wondering, Ms. Stowers, do you have any input? Because you were here, you were there. What is your impression of the effect of this on the smaller business owner?
I don't have a problem with this 20%, 80% that SEIU is recommending because it does help the small guy. I understand your particular client was more at a lower threshold. During that second IP meeting, a gentleman, a distributor, a retailer, he described his business practice, and he was at a higher percentage of what he was doing as far as whether he was selling it for retail or if he was distributing it. And based on how he described what he was doing, when I was at 80%, I thought that that particular business would have the benefit of this proposed regulation.
Okay. Can I offer a solution. Can we pass alternative number 1 with the purchase invoice required, timely police report, insert the cabinet, safe or cabinet, and then come back at the next hearing and address this substantially all issue? Because I think it's going to take a little more time for me to totally comprehend what impact that has on what we're doing here. Because it seems to be the only major bone of contention. The locked or inventory, I think we've kind of established is a problem, but I would like to see us move forward with what we have and then come back with staff to discuss this item number B, one more time, use what we have, and then maybe offer an amendment to that at the next hearing, but go with what we have in one with those few exceptions, because I need to understand exactly what we're doing here, how it impacts the whole picture. And I'm not so sure that I've got that.
If, for the sake of getting us trying to get to conclusion, I will second that.
Okay.
So are we taking it, adopting
We'll take it
the
and then we
regulation, or
adopt-
move it through the process, and then if we make more changes, we would have to go back and amend the...
My intent is to adopt it as is, and then to come back at the next hearing and address in separate form with more information, item B, but to adopt it as is.
Yeah, I would oppose that, members. The concern is I would be very supportive of Madam Chair dealing with this in its entirety, and in order to establish an understanding of the significance of the term and the language. To bifurcate this creates two separate processes, and that would be somewhat concerning unless General Counsel can figure out a way to do that. I mean, we adopt this measure and then begin to move it forward in our normal process, and then come back and open up another process, I guess.
No, it just does,
I think what we could do is we could actually adopt this portion of it, hold on the rest of it before we go ahead and send it out to
Well, that's the same thing.
well, except we've at least accomplished part of it. We've taken a lot of it off the table, and then we're down to some specifics that we want to come back and talk to. That's the only thing I think that's advantageous to move forward.
because we're down to one item then, Chair, Mr. Horton.
No, I mean, I agree with what you want to accomplish. It's just, I just think that if that's the case, then we just hold the whole thing over and keep it concurrent together. And I think all the members we all seem to be in an agreement, with the exception of that one item. Separating is, I don't think that's going to change that.
Well, I guess I'm talking about not holding it over as much as I am just completing that portion of it, and then, before we submit to OAL, we would go ahead and then wait till we finalize that last part, that's
It's
all.
the same thing.
Well, except that we would have accomplished.
Well, it's not, because then the whole thing is back up for another negotiation. And I see the language that keeps getting added, and pretty soon it's very not simple, and it's getting away from what we're trying to accomplish. Yes, Chief Counsel.
There's always two parts to these types of motions. There's the adopt and publish. So I think what you're talking about is you're contemplating adopting, but not publishing for purposes of a public hearing, and that you would make a later motion with respect to publishing any language that you would adopt today.
So let me make sure that I'm clear. So we would adopt this measure and then subsequently amend the motion or amend the action taken to adopt it, or basically rescind it, amend it, and then adopt it again, and then move it to publications. Is that?
Now, let me clarify the motion for you, Mr. Horton. What we do.
Well, I get the motion. I'm just asking for the legal opinion of how do we do it. I'm for it. I mean, I want to.
Okay, well, we would adopt it, and then we would, before we implement, we would review item B, and bring that back to the board at the next board hearing. We're adopting, but we're not publishing. I just don't want the whole thing back on the table again. This has been a very long
I
process.
get it, and maybe.
And I think we're down to one issue, which is still confusing, I think, at least for many of us, at least for myself, as to what I need to see it, I need to physically see this. I need to know what I'm talking about, and I don't know why we have to add this. I need to see why we have to add this. I will be going to investigations to see why we have to add this.
Another solution, Madam Chair, might be for the board to direct both parties that the board will not consider any additional items when it returns, with the exception of that one item. And I'm also okay with, if you want to adopt it and then rescind it and then adopt something new and then to publish it, both seem to accomplish the easiest thing, is to just direct the parties that the only items we will take under consideration in the future is the substantial all item, and when it returns, the other items from the perspective of the board is resolved and not up for further discussion.
Yeah, and I think it would be important to make sure staff, if you do go with adopting something today, that staff is really clear on what the interpolations to the current text are.
Well,
because
I'm clear on what we're adopting. We are adopting alternative number 1, adding purchase invoice required, timely police reports. We've already got police reports timely. And then the language in item 2, it says a safe, or we could have file cabinet. We can add file cabinet to that. And we're adopting everything excepting item B, which we will bring back to the board for further consideration.
One comment,
Yes.
Madam Chair, is the wire mesh.
I'm not a fan of the wire mesh. I think that you made a very good point, that it adds expense, it adds complexity for what is already a, not exactly a really high-income arena. We're talking about the smaller distributor. And I think the fact that we've got it segregated somewhere in one of these areas or up above high where it's out of reach kind of accomplishes what we were trying to do. So I know Mr. Horton feels differently, but I would like to refer you back to what we were thinking, was that it was an added expense, an added layer of complexity.
Madam Chair, I think the term was secure, and we was trying to determine secure. And just to try to put this in perspective, legitimate operators, we're not really talking about them. You're talking about the folks who are trying to evade the law or manipulate the law in such a way to be able not to comply with the law. And it's not one, it's not two. No, even if only 3 or 4 of them attend 3 or 4 individuals attend the interested parties meeting, they're not representative of this entire universe. This is trying to correct a redundant, recurring problem that exists. The ones that come before us are not really reflective of the universe as well. It's the ones that the investigation unit is prosecuting, which is significant. If my recollection of the numbers and the activity that never come before us, and the underlying purpose here is to actually protect the legitimate operator who is just having a huge challenge trying to compete with the criminals. But and I still would object to this adoption. Just doesn't need to kind of review the process and the law on that.
Procedure, let me just clarify real quick.
Go ahead.
So if indeed we adopted this portion, and then we came back and addressed the other portion, can we combine those then both together as we would then go and publish?
Correct.
Okay, so we don't have to undo anything else. we could just go ahead and then add that to what is being published.
Correct.
Okay. That, to me, is a very simple.
Okay, we have a motion and we have a second. I'm just going to call.
Okay.
Thank you.
Okay.
Ms. Richmond, will you call the roll?
Ms. Harkey,
Aye.
Mr. Runner,
Aye.
Ms. Ma,
No.
Mr. Horton,
No.
Ms. Towers,
No.
motion fails.
Okay, motion fails. I'm waiting for another.
I would like to hold it over, go back, get the language with all the suggestions that we currently have. Give you an opportunity to look at this substantially all.
Okay, will you make a motion?
Bring it back to the next meeting in April.
I mean, just to clarify, one of the issues that I'm concerned about, that as we continue this discussion, if we're going to hold it over till April, which I think is actually not that's
It need to be May.
that'd probably be May, right? Because I think we're in Culver City. I am concerned about all these discussions, and the interested parties kind of were engaged in there in terms of the business folks. I'm concerned that we're having a discussion here that impacts them that they have not been truly a part of at that point.
It just drags on.
And the impact. And so we may be making some choices about, screening and all these other things to which they were never engaged in during the interested parties discussion. And I'm concerned about them that, again, putting on that burden when they weren't even, they thought this was just moving along. So I guess I'm concerned about that, and I would hope that maybe the industry then, if we're going to bring this up at that point, is prepared to then also then present at that time the concerns that they would have. Is that a fair?
Fair.
Okay.
Understand.
So we'll be putting this over till the next board hearing.
May.
Yes.
May.
May?
Why May?
Why can't we do this in Culver City? Is it against the law? We can't do it? What?
No, it's not against the law, but I think we need time to be able to bring those other interested parties in for their feedback to make this language solid.
Okay, so May.
Okay. put it over
Madam
to
Chair,
May.
if I, just as another suggestion, maybe staff, I commend the chairwoman for going out and visiting the investigators and so forth. Maybe staff ought to have some conversations with the investigators. I believe.
I think that we have, Chairman Horton. They were there.
No, I mean,
We had.
over these specific issues, and not necessarily substantial law, just kind of codify the problem as it's sort of articulated and what a solution might be. SEIU is not here representing SEIU. They're here representing the investigators who they're engaging with on a regular basis. Mr. Alari himself is an investigator. So, this is what they do daily.
Okay, we have our instruction. Bring it back when you can. I'll be talking with you extensively throughout this, and let's be sure that we focus on the item B. Okay? Thank you so much. I think that concludes the Business Tax Committee, and thank you for everyone for appearing.
Thank you very much. I'd like to just manage expectations. We are going to hear the next Property Tax Committee, then we will take a 45-minute break for lunch. So whenever we are done with the committee, 45 minutes later, and then we will come back for the remainder of the afternoon.
Thank you, Madam Chair. The meeting of the Property Tax is hereby called to order. Mr. Young, I believe.
Yes.
Will you please introduce the issues in this case?
Yes. Hello, Property Tax Committee, Chairman Horton, and committee members of the board. My name is David Young, and I'm the Chief of the County Assessed Property Division in the Property Taxes Department. With me is Mr. Richard Moon of our Legal Department and Mr. Richard Reisinger of our State Assessed Properties Division. I bring before you today 3 items for your consideration. The first is the adoption of the State Assessment Manual. The State Assessment Manual provides the principles and procedures used by the board in the assessment of state-assessed properties. This revision updates the state assessment manual to reflect additions necessitated by statutory changes. The revision was developed through the interested parties process involving state assessees, industry representatives, and assessors. As a consequence, we believe there are no unresolved issues remaining. I am available to answer any questions you may have.
Welcome to the board. Please introduce yourself for the record, and let's see, we have two witnesses. Please, to both of you, please introduce yourself for the benefit of the board and the record.
All right. My name is Peter Michaels.
Don Gakel, Stanislaus County Assessor and Chair of the California Assessors Association Standards Committee.
Should I assume the two of you are together or separate?
We are separate.
All right.
Separate checks.
All right.
Separate checks.
I'm going to leave that one alone, Mr. Michaels. Mr. Michaels, please.
Thank you. Yeah, we have worked collegially with the staff for the last year, pretty much, on this state assessment manual. And so, first and foremost, I want to say that we support it. Industry supports it. And I worked with a coalition of leading industry, trade associations, and taxpayers. So bottom line is we encourage you to approve and adopt the manual as revised. This, I guess, there was one impasse between industry and the staff, and where that involved the discussion that's on pages 13 and 14 of the manual. Ultimately, we agreed to disagree, or we agreed to just sort of park it and go forward with adoption of the manual as is. But there were differences between industry and staff on the characterization of the treatment of intangible assets and rights under Section 110E of the Revenue and Tax Code. And we're happy that there are now in the glossary two important citations. This manual was first adopted and has not been updated since 2003. In 2008, a very important case was decided on the exemption for embedded software. That's the Cardinal Health case, and it is now in the glossary. And in 2013, an important case, at least in my opinion, on intangible assets and rights was decided, the Elk Hills Power case. That also is in the glossary. Last thing I would observe, and this handbook goes back to 2003. We have two other very important handbooks in my view and in the view of the courts. These handbooks reflect not only court precedents, but legislation that's been effected over the course of the decades. Assessor's Handbook number, Section 501, was adopted. Its basic appraisal was adopted in 2002. And Assessor's Handbook 502, which is advanced appraisal, goes back to 1998. So it would be, I think, helpful to the community, both assessors and assessees and consultants who try to give advice to taxpayers to update those manuals, which definitely are outdated. Thank you.
I would concur. Next witness, please.
Chair Horton, Board Chair Ma, and members of the board. My first time before the board, and as I was going through the process this morning, I signed up to speak on these things, so I thought I should come forward. But I will say, to make it simple, the California assessors were part of the interested parties process and have no ongoing issues with the manual or your item 2. I'm here today to speak about your item 3. So,
thank you. Discussion, members? Hearing none, is there a motion? Moved by Member Runner, second by Member Ma to adopt staff recommendation. Mr. Young to item 2.
Yes. The second item is Property Tax Rule 462.040, change in ownership, joint tenancies. We are seeking authorization to initiate the rulemaking process for Property Tax Rule 462.040. This rule prescribes which transactions involving joint tenancies are reassessable events for property taxation purposes. This revision amends the rule to include additional examples and rearranges examples for ease of use. It has been through an extensive interested parties process involving county assessors, county councils, and industry representatives. I ask for your authorization. I ask that you authorize starting the rulemaking process. I'm here to answer any questions you may have.
Discussion, members? Hearing none, Member Ma moves to authorize the hearing process, second by Member Runner. Without objection, members, such will be the order. Ms. Young to item number 3.
The third item I bring before the Property Tax Committee for discussion and to seek direction on is an opportunity to streamline the property tax welfare exemption clearance certificate process. Nonprofit entities seeking an exemption from property taxation must apply and be issued an organizational clearance certificate. Limited partnerships have an additional requirement that their general managing partners must also receive a supplemental clearance certificate. Staff has prepared and distributed a white paper describing the duplicative requirements an applicant must fulfill to obtain a supplemental clearance certificate and to apply for the exemption with the county assessors. I ask that you direct this issue to the interested parties process to discuss options to reduce the duplication of effort and to expedite the exemption process. Once again, I'm available to answer any questions you may have.
Thank you. As the witness comes forward, we would ask that they introduce themselves for the record, and we'll go to our second witness after that, then return to you, sir.
I'm not sure who's one or two, but
You are.
I'm Joel Rice, law offices of Patrick Sable House, representing California Council for Affordable Housing.
Welcome.
Chair Horton, members of the board, the assessors received the white paper approximately 10 days ago, and at that time, it was we hadn't had any prior discussion on the issue with board staff. It did generate some interest among assessors, and we have submitted that to our exemptions subcommittee in our standards committee for review and a report back to the committee. The assessors are meeting next week in conference, and all our committees will be meeting, and this issue will be on our agenda. To the extent that this hearing today is to decide if the board should go forward at this time with the interested parties process, the association would suggest it would be maybe helpful to the board to have input from the Assessors Association prior to beginning that process to flesh out any issues that are outstanding.
Thank you, sir. Now it's your turn.
Actually, if the purpose is only to consider putting the issue before the interested parties process, I think I've spoken to people who are in the industry from all over the state on the applicant side for this exemption, and there's really no opposition per se. I had some discrete issues to speak about as far as the forms themselves and so forth, but I think I'm way ahead of the game here with those specific comments. So if we're just deciding whether to move forward with the interested parties process, we're not opposing that.
Mr. Young, can you share with us the process and the timing? Maybe the assessors will be satisfied that sufficient time would be available to them to finalize their process and provide their input, which we value immensely.
Yes, sir. Our interested parties process would involve gathering both industry and assessors in getting their opinions. Unfortunately, the meeting that CA's meeting is next week. We will not be able to accomplish that before the meeting. So, but our Our normal processes run probably about 3 to 6 months in the full vetting of the issues.
So 3 to 6 months, would that be sufficient time for the committee to meet and share with the department their views?
Oh, yes.
Okay. And the request today is to start that process?
Yes, sir.
Okay. Discussion, members? Member Ma moves to direct staff to start the interested parties process, second by Member Stowall. Without objection, members, such would be the order, and we very much look forward to the assessor's input in that regard.
Who's music?
Yeah, I think that was the lunch bell.
Does this conclude your committee?
Then we got one
Does this
more.
conclude your committee? One more?
You got the rig, it threw me off a little bit. Does that conclude your presentation, Mr.
Yes.
Young?
Yes, sir.
Thought that was 3.
We've got one more. We're good.
Right.
I was here to answer questions of the
Okay,
board
good.
if they had it with respect to
All
the
right.
SAC process.
Members, the meeting of the Property Tax Committee is hereby adjourned. Thank you for your engagement and involvement.
Thank you all.
Okay, thank you. This concludes the board committee meetings. These meetings are hereby adjourned. The meeting of the Board of Equalization will reconvene in 45 minutes. So reconvene at 1:15.
Got an extra 2 minutes.
Crank us up.
Oh, was just about to email you.
Thank you, Madam Chair.
Okay. Good afternoon. We are going to reconvene the meeting of the State Board of Equalization. Ms. Richmond, will you please call the roll to determine a quorum is present?
Chairwoman Ma,
Here.
Ms. Harkey,
Here.
Mr. Horton,
Here.
Mr. Runner,
Here.
Ms. Dowers,
Here.
Thank you. Seeing a quorum is present, Ms. Richmond, please introduce our next item.
Our next item on this afternoon's agenda is Chief Counsel Matters, Item J, Rulemaking, Item J1, Sales and Use Tax Regulation 1506, Miscellaneous Service Enterprises.
Okay, thank you, Mr. Heller. Please proceed. Please introduce yourself for the record and proceed with your presentation.
Thank you, Chairwoman Ma, members of the board. I'm Bradley Heller from the board's legal department, and I'm here to request that the board authorize staff to complete Rule 100 changes to Regulation 1506, Miscellaneous Service Enterprises, to update the name of the entity within the Department of Consumer Affairs responsible for licensing persons who dispense hearing aids.
Thank you. Seeing no one from the public, members?
Move to adopt the changes.
Second.
Okay. Mr. Runner moves to adopt the changes, seconded by Mr. Horton. Without objection, motion carries. Next item, Ms. Richmond?
Our next item is Item M, Other Chief Counsel Matters, Item M1, Lucent Technologies, Inc. versus State Board of Equalization and Sales and Use Tax Regulations, 1502, Computers, Programs, and Data Processing, and 1507, Technology Transfer Agreements.
Welcome, Mr. Ferris and Mr. Tucker. Please introduce yourself for the record and then commence with your presentation.
Yes, I'm Robert Tucker with the board's legal department, and with me is Mr. Randy Ferris, our chief counsel, here to discuss Lucent. As the board is aware, on January 20th, 2016, the board's petition for review of the Court of Appeals opinion deciding Lucent Technologies, Inc. versus the State Board of Equalization was denied by the California Supreme Court. Accordingly, we're here to present options for the board to consider in order to implement the Lucent decision. In Lucent, the Court of Appeal applied the provisions of Revenue and Taxation Code sections 6011, subdivision C10, and 6012, subdivision C10, which are collectively the Technology Transfer Agreement, or otherwise referred to as TTA statutes. These were applied to transactions in which AT&T Corporation and Lucent Technologies sold telephone companies 1, switches used to connect telephone and data networks, 2, written instructions on how to use the switches, and 3, copies of copyrighted switch-specific software and generic software recorded on tapes and disks, which were each subject to at least one patent held by Lucent, together with the right to copy the software onto the switch's hard drives and the right to use the software to route calls and data and to offer call waiting and other features to their customers. The Court of Appeal held the transactions constituted software TTAs because 1, the software was copyrighted and patented, 2, Lucent established that it was the holder of the copyrights and patents, and 3, Lucent established that it transferred a portion of its copyright and patent interest in the software to the telephone companies so they could produce telephone products that were subject to Lucent's copyrights and patents. The Court of Appeal also held that under the TTA statutes, the charges for the right to copy and use the software under the TTAs were not subject to sales and use tax, but the price of the blank media transferred, were not subject to sales and use tax, but that the price of the blank media transferred was subject to tax. As more fully explained in the Chief Counsel memorandum to the board, the legal department makes 3 recommendations to this board. First, we recommend making amendments to Sales and Use Tax Regulation 1507, Technology Transfer Agreements, to clarify the requirements that establish an agreement for the transfer of software on tangible storage media is a software TTA in accordance with the primary holding in Lucent, and to clarify the measure of tax when software is transferred under a software TTA, and also to make conforming amendments to Regulation 1502, Computers, Programs, and Data Processing. In accordance with the holdings in Lucent, the legal department recommends the board makes amendments to Regulations 1502 and 1507 to clarify 1, the requirements to establish an agreement for the transfer of non-custom software on tangible storage media is a software TTA. The measure of tax when software is transferred under a software TTA. And the measure of tax when storage media on which software is placed is sold at retail in a non-TTA transaction. Such rulemaking would need to consider the correct application of tax to transactions involving exclusive holder retailers, non-exclusive holder retailers, and non-holder retailers. Procedurally, we recommend rulemaking could be initiated through either a Chief Counsel Matters agenda item or an interested parties process overseen by the Business Taxes Committee. Second, the legal department recommends the board issue a notice to clarify, one, that typical off-the-shelf retail sale of canned, mass-marketed software still does not constitute a software TTA because the typical retailer can only sell the tangible storage media and does not hold any intangible copyright or patent interests in the software to transfer with the storage media. And two, Lucent is only dispositive with respect to software transmitted on tangible storage media that is wholly collateral to the subsequent use of the licenses regarding the software and is not dispositive with respect to embedded, non-custom software or preloaded non-custom software. These items were not at issue in Lucent. Although the board is not obligated to do so under Lucent, the board also has the option of considering rulemaking for sales and use tax purposes with respect to these transactions involving software embedded at the time of manufacture. Again, any such rulemaking would need to consider the correct application of the tax to the transactions involving exclusive holder retailers, non-exclusive holder retailers, and non-holder retailers. And finally, the legal department recommends or acknowledges that certain refund claims may be potentially ready for immediate processing. Based on the Lucent opinion itself, unless the board directs staff otherwise, staff is prepared to begin processing immediately, meaning prior to the completion of any rulemaking, any timely, valid refund claims for which staff can verify the existence of a software TTA between an exclusive holder retailer and purchaser licensee, pursuant to which software was transmitted on tangible storage media, which is wholly collateral to the subsequent use of the licenses regarding that software. Under Lucent, it's clear that the taxable measure for such software TTA transactions would be the retail fair market value of the storage media, which is deemed to be blank, without reference to any potential like transactions involving third-party vendors. Thank you very much.
Thank you. We have one member of the public here today to testify, Ms. Charisse Toomey of the California Taxpayers Association.
Good afternoon, members, and thank you so much for the opportunity to present testimony. In the Lucent decision, Lucent made very clear what was taxable and what was not taxable, particularly to the items at fact in the Lucent case. However, as indicated in the Chief Counsel's memo, there are still other areas that need guidance from the Board of Equalization. And as the board deliberates these issues, we ask that the board consider three overarching principles in providing such guidance in addressing issues specific to whether or not Lucent is applicable to embedded software and how holders and retailers and non-holder retailers would be subject to the measure of tax. The first principle that we like to address is a reasonable test. And when we talk about reasonable tests, what we're saying is we're asking the board to provide an interpretation and an implementation program that is neither too broad, such that all taxpayers with de minimis sales tax who have ever purchased any software would be subject to a refund. We think that is too broad, and that would be something that the court would likely consider quote-unquote absurd under their interpretation. And there's precedent for having a not too broad interpretation under Loeffler versus the Target case, in which a taxpayer brought suit for imposition of sales tax on hot beverage. We also ask that under the reasonable test, that the provisions not be interpreted too narrowly, that we look at the spirit and the intent of the legislation and not to exclude things such as embedded software. We're concerned that such an interpretation may lead to further litigation and another lawsuit. The second principle that we ask the board to consider is ease of administration. As outlined in the Chief Counsel's memo, there are a lot of implementation concerns not only for the Board of Equalization, but also for taxpayers. We ask that to that end, the board considers centralized processing of refunds at the board. This is something that would streamline the process as well as provide for more consistent application of the refunds. There's also precedence for doing this when the Board of Equalization process refunds in the Dell case. But beyond just processing refunds, we ask that the board consider future administration. Going forward, how do retailers and vendors and manufacturers provide a framework so that not only are they able to track what is taxable, what is not taxable, but how do we as businesses provide an audit trail that is easily accomplished through our reprogramming costs and taking into consideration how much it would cost businesses to reprogram, as well as to take into consideration what the Board of Equalization staff costs would be. Lastly, a concept that we ask you to consider is the market neutrality. And when we talk about market neutrality, we're talking about the equal measure of tax between holder retailers, holders, and non-holder retailers. The memo outlines an approach. I think the intent is to get there, but we'd like to have more discussion with the approach. The approach that's outlined, we're concerned about because it may be overly cumbersome and perhaps too costly for businesses that we represent and others, particularly smaller businesses who may be impacted, for them to be able to comply with. With these goals in mind, we ask that if the board were to adopt any kind of notice or issue a notice today, that the notice not be too prescriptive, because as we've outlined, these are some of the goals that we'd like to achieve. We'd like to work with the board to achieve these overarching principles, but it's a complex issue that requires careful thought and approach to how it's administered. And with that, we look forward to working with the board and your legal staff on implementation.
Thank you, Ms. Jimmy. Okay, members, discussion? Mr. Renner.
Just a couple of, to kind of start off with just some clarifications on a couple of issues. Let me start off with from Caltax. The issue of centralized refunds. Can you help me understand? Can you lay out for me what the other alternative would be?
The other alternative, which we would not be supportive of, is to direct the vendors and the retailers and certain other manufacturers to issue a form, process refunds that would not go directly to the Board of Equalization. There'd be a two-layer or three-layer process in which the retailers would be the ones accepting refund claims from the taxpayer, as opposed to going directly to the board.
Okay. The issue of the market neutrality, is that the issue there in regards to the manufacturer who also may retail and then also may use another retailer?
Yes.
Okay.
Yes. And, you know, I think the staff memo's intent is trying to achieve market neutrality. However, it's going to be very difficult for us to definitively say that, yes, this measure of tax and this pricing is going to be the same as what's sold at retail by a non-holder retailer versus one that's being sold by a holder retailer. And that's because with IT products, there's pricing promotions, there's agreements for a short period of time. It would be administratively cumbersome, if not impossible, for businesses to provide that kind of tracking in order to provide any audit trail to prove that we are consistent with that kind of requirement. I think that's the intent, and we like the intent, but I think there's different ways to approach it.
And then the other issue is in regards to the reasonableness test. I'm trying to. Well, let me start with saying this. I believe our best path to go down through this is using the BTC. I think using a interested parties process in order to fully vet and engage everybody is a good path at that point. So let me ask you this: in regards to then the reasonableness test, I'm not sure exactly, in your opinion, what would be the language to which this board would be instructing the BTC at that point, or is just this discussion help providing that kind of direction? And I'll give that to both you and also then to to council?
I think it's going to be a work in progress as we take a look at the fiscal implications of what it is that the Board of Equalization has in-house right now, and potentially, what are the outstanding refunds still. We don't want to be in a situation where we bankrupt the state by having every single taxpayer who's ever purchased a de minimis software, be eligible for a refund. I don't think that's the board's intent. I mean, that would be the very extreme. But we do not believe that Lucent would eliminate any possibility for exemption on embedded software
You
either.
believe that, what about the thought, I mean, again, I agree, but I think the fine line that we end up walking is to make sure that as we interpret then what is taking place at the court, and we apply that to other places, that we don't, in our effort to not be too broad, we interpret too narrowly, which then leads to potential other litigation?
Yes, it's likely that if embedded software were not included, I mean, from what we're hearing, there's likely going to be potential litigation, follow-up litigation.
Okay. Let me ask, in regards to the refunds that are out there, do we have any kind of a thought in regards to, again, I'm talking about the category of refunds that we believe fit clearly into the court case right now. And so I guess it would be the facts themselves clearly identified this group of folks who would then be eligible for refund. Do we have any idea in terms of the number? I guess both I guess the dollar number. Do we have any idea?
I don't think we do. I don't think staff has, I think there are roughly 900 pending administrative refund claims, about a third of which specify a specific refund amount and two-thirds of which do not. But even with
we don't even know of the 900, how many actually then fit the facts of the case versus what we may need to do through the regulatory process.
Correct. Staff has not analyzed it to see which claims involve storage media that was transferred that's wholly collateral to the copyright and patents that were assigned.
Okay. Thanks.
Ms. Harkey.
For legal, I think one of the biggest issues we will have, the largest issues we're going to have to address is the Lucent is not dispositive as to transactions involving embedded or preloaded software. Can you expand on that as to what you see the potential being? Because you're saying it's not dispositive. Lucent was decided on a specific set of facts.
Right.
And that's really what we're trying to address here, is that specific set of facts. What can you see, or do you see coming forward on the specific set of facts that we're not addressing, I guess?
Right, and just to be clear, dispositive is kind of a lawyerly term, but we're using it just to because we think it's important for it to be clear to the public and to our retailers that the Lucent opinion is, as you said, is dealing with a very specific kind of fact pattern that was an exclusive holder retailer that was transferring the storage media that was wholly collateral to the exercising of the rights that were also transferred. So that's what that case was about.
There was an agreement, and everybody was party to it.
Right.
Right.
And that's why we can begin to process similar claims immediately. We don't need rulemaking. We don't need any interpretive guidance from the board with respect to that kind of fact pattern. But for other things like software that's embedded at the time of manufacture that could potentially be part of a TTA transaction, what we're saying, by saying that it's not dispositive with respect to those types of fact patterns, is the board needs to engage in its policy and interpretive function to the extent the board wants to apply the guidance that the Lucent opinion might give towards analyzing those types of other fact patterns. That would be what this interested parties process potentially could be about, depending upon how broad the scope the board refers to the Business Taxes Committee, if that's the path that you take. But we wanted to make it really clear that anyone who thinks they might have a potential refund claim with respect to embedded software issues needs to be coming to the Board of Equalization to go through the administrative refund process. The Lucent is not dispositive in such a way that you could avoid coming to the Board of Equalization to pursue the administrative refund claim. So,
Thank you. So Therese, I guess this is probably maybe you can't quantify, but to what level are you, I mean, what we're trying to do right now is get out the refunds that qualify under Lucent. What level of engagement would you expect there to be on the other end?
It would be up to the board whether the board wishes to pursue this through an interested parties process, or whether the board wishes to pursue this as a chief counsel matter. We will be engaged, as we have engaged with all of you through either process. We agree that the claims that currently meet the fact patterns of Lucent ought to be refunded, precipitously and expeditiously. Going forward, it would be up to the board on your time frame, but we will be there in either process.
Okay, because I think we need to establish some parameters, otherwise we'll be legislated. So, that's kind of the options here. Okay, thank you.
Anyone else? Okay.
I agree with Mr. Runner. Should be the Business Tax Committee. It provides for far more engagement with the general public on the matter, the process, the timing. Also, that's not to say that the coming forth as a chief counsel matter does not also provide that same level engagement. It is the perception of the public that may be a little more exclusive, if you will. So I would concur with Member Runner in that regard.
So do we have a staff recommendation today?
right. So staff would recommend that you refer the implementation of Lucent to the Business Taxes Committee, and that the board also authorize staff to issue a special notice that would specify what Lucent is dispositive with respect to, and would also notify interested parties about the Business Taxes Committee interested parties process with respect to the other issues that the board may be prepared to engage in with respect to implementing Lucent.
Ms. Toomey?
With respect to the notice, may we ask that the board prescribe in that notice only what the decision was depositive of and not what it was not depositive of? Going back to Vice Chair Harkey's comment about embedded software, we're concerned about any notice that is too prescriptive and indicates that it's not depositive of embedded software. Those in the legal world understand what that means, but those outside may be looking at interpreting it in a different way. So once again, our request would be to have the notice identify what it is depositive of and be silent on what it is not depositive of.
Well, I envision a special notice that would specifically state what the board is going to consider through the interested parties process, which if the board says you want embedded to be discussed there, then the special notice would say that. So I think it would be clear. Yeah.
I'm ready to support staff recommendation.
Second.
Okay. Ms. Harkey moves. Mr. Horton seconds. Motion carries. Thank you. We look forward to this ongoing process.
Thank you.
Thank you.
Okay, Ms. Richmond, please introduce the next item.
Our next item is the administrative session. We have item N, consent agenda. N1, we have retirement resolutions for Cheryl A. Blakely, Karen Fabiano, Susan W. Lee, Deanna Payne.
So on behalf of the members and the Board of Equalization, we extend our sincere appreciation to these retirees. I'm just going to give a little brief description of each member, and I'm sure other members will chime in. Ms. Cheryl Blakely is retiring after 30 years of state service. She began her career in 1974 as a Clerk 1 in the Employment Development Department prior to coming to the BOE. In 2006, she worked for several other state agencies in the positions of Clerk 1, Office Assistant 2, Office Services Supervisor 2, Office Technician, Team Associate, Business Services Officer, and Associate Governmental Program Analyst. In 2012, Ms. Blakely was promoted to Staff Services Manager in the Acquisitions Procurement section, where she is still currently working. Ms. Karen Fabiano is retiring after 28 years of state service. She began her state career with the BOE in 1989 as an office assistant in the occasional sales section of the Sales and Use Tax Department. She promoted to senior account clerk in April 1990 with the Audit Control Unit, and then was promoted to Tax Technician 3 in April of 1994. Karen transferred to the Business Integration Unit of the Technology Services Department in December of 2001 as an Assistant Information Systems Analysis, was promoted to Associate Information Systems Analysis in November 2002, promoted to Staff Information Systems Analysis in July 2004, and promoted to Senior Information Systems Analysis in the Enterprise Planning and Analysis Unit in January 2009, and then transferred to the Centralized Revenue Opportunity System project in June 2013, where she is still currently working. Lots of promotions. Ms. Susan Lee is retiring after nearly 38 years of service. She began her state career with the Board of Equalization in 1977 as an auditor in the Pasadena office. She promoted to Tax Auditor 2 a year later, to Associate Tax Auditor in 1982, to Staff Information Systems Analyst and Land Coordinator in 2002. She transitioned to the Technology Services Department in October 2015 and is currently based out of the West Covina office. And our final retiree today is Deanna Payne, retiring after 36 years of state service. She began her state career with the Board of Equalization in 1980 as an Office Assistant 2 in the Excise Taxes Division. She promoted to Senior Account Clerk, Business Taxes Representative, Staff Services Analysis, Associate Governmental Program Analyst, Associate Program Analyst, and her current position of Staff Information Systems Analyst in the Technology Services Department. I see a lot of them are in Ms. Fleming's group based on the bio. So congratulations to all on their retirements. The other members?
Yes, thank you, Madam Chair. As the Chairwoman has articulated, it represents 132 years of exceptional service to the people of the state of California, and Susan Lee, who I happen to know personally, as kind of grew up with here at the Board of Equalization. It also exemplifies the family unit that we have here and the need for retention, recruitment, and parity salary compensation for those who are left behind. Just thought I'd plug it in there.
We had,
Anyone else?
I want to congratulate all of you and wish you luck in your retirement and whatever you choose to do. You're probably all young enough to get on to the next life. I did notice that Christine Demas is also retired, and we didn't have a resolution for her, but I just want to wish her well as well. That's what I got in my notes.
That will be on a later agenda, Ms. Harkey.
Is it on later agenda?
Yes.
Okay. Well, then, congratulations anyway. She's an add to me. She'll get it twice.
Okay.
I just want to say congratulations on your retirement. Enjoy your time. I will go by the beach.
The beach.
Okay, thank you. Madam Clerk, please read the next item.
Our next item is N2, approval of board meeting minutes for February 23, 24, 2016. Item N3, proposed revisions to Compliance Policy and Procedures Manual, Chapter 2, Registration, Chapter 7, Collections, and Chapter 8, Consumer Use Tax. Item N4, proposed revisions to Audit Manual, Chapter 1, General Information, Chapter 4, General Audit Procedures, and Chapter 6, Vehicle, Vessel, and Aircraft Dealers.
Move to consent calendar.
Second.
Okay, Mr. Runner moves, Mr. Horton seconds to adopt the consent calendar without objection. Motion carries. Ms. Richmond, please introduce the next item.
Our next item is item O, adoption of board committee reports and approval of committee actions. We are just now passing out the minutes for the Legislative Committee and the Customer Service and Administrative Efficiency Committee. We're waiting for the Business Tax and Property Tax minutes, so would you like to put this item over?
Okay, good.
Please.
Yes, please, so we can take a little time to review it. Okay, next matter?
So our next matter is item P, other administrative matters. P1 is our Executive Director's report. P11 is the update on resolution of State Controller's Office Board of Equalization review.
Okay, Ms. Bridges, welcome, and please introduce yourself for the record and commence with your presentation.
Good afternoon, Madam Chairwoman, members. My name is Cynthia Bridges, Executive Director. I am here today to provide an update on our efforts to resolve findings in the SCO's review report and on actions taken to resolve the BOE's internal accounting and administration controls in coordination with the SCO. At the outset, regrettably, the BOE received no bids in response to our solicitation of a CPA consulting firm to review BOE's corrective actions under the SCO's review and make recommendations for improving the BOE's financial management practices. Although 24 firms viewed the IFB, no bids were received, but we are in the process of contacting these firms to determine if there are any common issues which contributed to their decision not to submit bids. Upon review of these responses and in consultation with the Board Member Review Committee, Chairwoman Ma, and Deputy Controller Stowers, a decision can be made regarding the resubmission of the IFB or any other alternatives. We are pleased to report that significant progress continues to be made in resolution of the issues identified by the State Controller's Office. We briefed board members individually regarding our progress on the work done and the issues and challenges that remain. Some challenges are rooted in IRIS, e-file, and process limitations. Though problems continue because of IRIS and other systems, we identified the revenue accounting gaps for the development of solutions upon the implementation of CROS. Until that time, our teams have put in place some temporary workarounds, and we continue to explore more. Regarding the RSTF allocation challenge, since the majority of the returns are filed quarterly, a daily allocation to the various funds is accomplished via statistical factors, which are based on previous filing period reports and payments. Our teams have, therefore, increased the frequency of remittance reconciliations, modified the quarterly allocation reconciliation process, and identified new reports to monitor trend deviations to enhance accuracy. Regarding daily remittances, including funds received from other agencies charged with collecting portions of the retail sales and use taxes, such as the Department of Motor Vehicles and the Franchise Tax Board, we are accounting for these and incorporating them into the quarterly reconciliation process. To address the challenges of silos, data gaps, and other deficiencies identified in the SEO review, we've established the following 4 accounting process improvement teams to recommend solutions and draft the corrective action plan and proposed timeline. And they are the Retail Sales Tax Fund Accounting and Allocation, Office Revolving Fund Management, Internal Controls, and Business Systems. As a result of the team's efforts, an adjustment was identified to correctly allocate the additional sales tax on diesel fuel and the use tax collected by the DMV and FTB for the period of July 1, 2011 through June 30th, 2015. Upon approval of the board members, the Board Member Review Committee, we will recommend this adjustment at the board's Culver City meeting in April so that monies can be timely reallocated to the various state and local funds in consideration of local government's next budget cycle. Any refinements of this adjustment can be made upon a further review by a CPA firm that is ultimately procured or by any other alternative that's pursued. Regarding other corrective actions, BOE's Internal Audit Division is serving in a consultative role to the Financial Management Division in developing and implementing internal control and monitoring processes. Now, Ms. Julia Finley will briefly walk you through an informational PowerPoint.
Good afternoon. Let's see, get up to our first slide here. There we go. I just kind of wanted to walk through very briefly about the sales and use tax rates and the factor funding. As you can see from this diagram, on the left you have the tax rates and the various allocations, the funds that they would go into. And on the right-hand side is just the factor-funded allocation. As Ms. Bridges just mentioned, that factor-funded allocation is based on historical reporting. It is prepared by Research and Statistics and submitted to accounting to enter into the IRIS our computer system on a quarterly basis. As you can see, the factors pretty much emulate what the tax rate is. The allocation is very consistent with the associated tax rate. On the next slide, I just kind of wanted to briefly go through our daily collection and allocation process. On the left, you'll see that daily we receive various forms of payments. We receive prepayments for the fuel tax returns, prepayments on sales tax returns. We receive returns and return payments. We have audits that come through and associated payments. We have payments on accounts receivable. All of those come into the Board of Equalization, and they're deposited into the State Treasurer's Office, into our account in the State Treasurer's Office. By 2 p.m. every day, our team in the accounting area puts together a TC-47, a form that goes over to the State Controller's Office, and it says this is how the funds should be allocated. And you'll see those are the buckets on the bottom is how they are allocated based on the factor funding that we just went through in the previous slide. So a portion of it goes into the general fund, some of it goes to state local revenue fund, the local public safety fund, the local revenue 2011, and then on the right-hand side is the Bradley Burns and the special taxing jurisdictions. The IRBA, which was called the triple flip, expired on 12/31/15, so it's no longer part of our allocation process. Then, at the end of the quarter, what we do is take all of those cash receipts that we just went through and the allocations that were funded based on factor funding, and we compare those, or we reconcile those to what was reported. And the reported includes the DMV, the FTB, everything that came in, audits, accounts receivable, payments on returns, everything that came in during that quarter is included in a report that comes out from our computer system, and we compare that report to what was remitted to the State Controller's Office. Ms. Bridges had mentioned that we still have some IRS report issues, and some of our issues with the reconciliation have to do with trying to true up this IRS report with what actually came in on the remittance advices. They're not exactly apples and apples, and that's the processes that we're trying to work through to get these reports from our system that would allow us to compare those appropriately. So what we do have is the fund allocation corrections. As she indicated, we've reviewed the periods of July 1 of 2011 to June 30 of 2015. We have a solid number relative to the diesel fuel since inception for the misallocation there, and that's just the additional sales tax on diesel that needed to go to the general fund. We've determined what the DMV misallocations are and the Franchise Tax Board misallocations. We're very confident in those numbers, and that's what will be going forward to the Culver City meeting in April. In addition to the actual allocation, we've also instilled some of our own corrective actions, and we're working on others. We have, as I indicated, we daily reconcile the BOE, what came into the BOE with the State Treasurer's Office, with the State Controller's Office, make sure they all match. We have segregation of duties. We have we've instilled managerial approvals, so there's a sign-off before things move forward to the Controller's Office. We have regular communications with all the units involved in the revenue process. We have management reports where we're taking a look at the past and forecasted so that if there's anything unusual, it should stand out. We've ensured that we have a solid audit trail, so it'd be easily, if someone wants to look at a number, be able to go right to the backup and what that is. We've documented many of our procedures and processes. We ensure that we timely remit to the State Controller's Office on a daily basis. We have cross-training going on in some of the areas, so we can ensure that if someone's out, another person can pick up and continue on with those functions. We have an annual training plan into place for the first time. I'm very excited about that. We've documented many of our processes and have process maps, and we make sure we have regular meetings to keep a status on how we're doing and where we're going next. Some of the other controls that we're working on are in progress is, of course, the redesigning and the creation of some of the IRS reports, a workforce and succession plan. We're working on that right now, clearly defining the roles, responsibilities, and accountabilities of staff. We have the Internal Audit Division that's helping us in a consulting process, and we have our first training on that on April 6th. Developing reports that we think are accurate and relevant, make it more useful. Instilling regular communications with control agencies. Ensuring that our staff knows to let someone know if there's any dishonesty or fraud that they may notice. Identifying processes that require management approval and making sure that we instill those approvals in place. Involve internal and external parties in the periodic review of our records to make sure that we're doing a good job. Establishing performance matrix and monitoring those matrices to see how we're doing. Making sure we fill our vacancies, making sure our staff understands that they need to constantly look at ways to improve efficiencies, evaluating whether or not we need to add some components to our accounting package so that we have a whole accounting system in place, making sure that we're involved in CROS and that we fix CROS so that it can do some of these things for us, and then just making sure that we are constantly analyzing and reconciling our accounting data through multiple sources, so you have more than one verification or means of making sure that we have it right.
And to supplement Ms. Finley's comments, I'd also like to mention that there are other solutions that are also being considered that do have impact to stakeholders, and I am requesting that there be a more in-depth meeting with the reviewing committee members, Chairwoman Ma and Yvette Stowers, so that we can provide a little bit more information and details about that in the near future. The draft corrective action plan to address all underlying issues in the SEO review will be distributed to the board members for review by April 15th, 2016. Once final, this report will be transmitted to the State Controller's Office by May 18th to complete the 6-month review process. I'd like to commend staff for their excellent and diligent work in response to the SEO review, and we look forward to communicating with you on further updates as additional corrective actions are implemented. Thank you.
Thank you.
Thank you. Ms. Stowers?
Okay, thank you. Halfway there, you've completed a lot as far as your task on this side, so congratulations.
Thank you.
Very pleased with the annual training plan, CROS training, timely remittance to SEO, and most important, daily reconciliations. But we still have a lot to do on the other side.
Yes, we do.
With respect to the fund allocation, if I understand, you're going to be meeting with myself and Chairman Ma about it, and then would like to come to the board in April for our approval. Is there another step in there? Will you be communicating with the Department of Finance?
Yes, we will be communicating with DOF and also with SEO.
Would that be before April, before or after April?
We will be doing it between now and the April board meeting. Yes.
That was it.
Okay, I have a couple questions. On page 3, it says BOE deposits all money with the state treasurer's office
Yes.
versus the state controller's
bank.
office.
That's our bank. The state treasurer's office is our bank.
And then the controller.
So then yeah.
Oh, and then the controller. So it looks like it just goes to the state treasurer's office and then it doesn't come back out. So
The state treasurer's office has access to the program that we use with the state controller's office. So once we've made that allocation, then they move the funds to the appropriate place.
okay, got it. So SEO is someplace in here. And then on page 6, in the in-progress/planned column, instill regular communications with control agencies. What does that mean, or what do you propose?
I'm hoping that I can set up maybe monthly meetings with the State Controller's Office, Department of Finance. Currently, we do communicate with them on an ongoing basis, but we don't have a structured communication plan in place. And since Fiscal's coming on board and we're going to be making changes to our reports, it just seems like it would be a good opportunity for us to sit down with these agencies and CROS, because we're going to be building in some new things to try to make sure that we are all efficient in our processes together and that we just have good communications with each other. So
That would be great, because I think that that hasn't been happening, and I would encourage you to reach out to more agencies.
Thank you.
In a more collaborative process. I think it would make it easier in terms of all of our, our complexities and dealings with so many of these different control agencies. When you say fill vacancies timely, I am also concerned that, there is personnel that is hired that's able to do fund accounting, that understands, what amount we're supposed to be collecting, what amount we're supposed to be allocating, and to make sure there's checks and balances to make sure that we're allocating correctly. So when you're talking about vacancies, not just anybody, but, specific people perhaps who understand how to do the fund accounting that's necessary for.
Absolutely, and I think you'll see on the left-hand side where it says we completed an accounting staff classification study. We have 35 people in the accounting realm in our area, and of those 35, 29 of them are degreed in accounting.
Okay.
So I'm very proud of that statistic, and so now it just tells me that we just need to really work on our training efforts, and the fund accounting is a large component of that, although they really do a stellar job of working around, and they've had to do workarounds with a system that's not an accounting system, a revenue system, to try to make this all work. So we've done a great job in that area.
And I guess on the RFP level, the fact that 24 firms actually opened it and looked at it but didn't apply, there's probably some issue around this. And if we can't get firms to submit an RFP, perhaps we have to go internally to people who can do this check and balance, people who have been doing it for many years, who understand fund accounting, making sure that all of these completed tasks as well as the ones in progress and planned is what's going to get us to better accounting records and management. So, we have a lot of different agencies. They're all set up differently. They all have, accounting personnel. They're making sure that all of their fund balances are correct. And so that may have to be a possibility to try to draw the best and the brightest from within state government to kind of do this third-party independent outside review.
Actually, I am requesting, I think I sent some communication requesting a meeting with the subcommittee or reviewing committee sometime next week so that I can review more in depth some of the results from the surveys that we received and discuss some possible options.
Ms. Sarkey.
I would just like to commend you and your staff. Julia, you've just done a fabulous job on this. I'm very, very confident with what you provided to me. I think you speak affirmatively that you have managed to weed through and find out where some of the areas were. One of the items that came to light is that we had funds, of course, that we had not transmitted, that we thought that were automatically being transmitted. And what I thought was interesting about that is that the agency that we were supposed to transmit them to didn't actually even know they weren't there either. So, it's not necessarily a BOE problem. I think that statewide, we need to be sure that if one's supposed to receive something, that the other one is remitting, and vice versa. It can go both ways. I'm just really happy that we had this audit and that these things are coming to light, because I think we do have good, competent staff, and now we have a roadmap to get this resolved, and it sounds like they've got most of it resolved. So I want to thank you very, very much for what you've done and the hornet's nest you flew into. And I do appreciate the fact that you've got 29, accredited or degreed people. And so I think it might behoove us to, encourage those people, as you are trying to do, to, get positions filled, allow for the promotions, and get everybody on board in a professional manner. I thank you very much.
Thank you.
Any other?
Yes, Madam Chair.
Mr. Horton.
Let me add my congratulations as well for addressing this issue and bringing it to the point that we are currently at, and to encourage us to continue to move it forward. I concur with Member Ma relative to us taking a look at whether or not we return to the original recommendation of looking at the state auditor, and I think there were a number of other options that the staff provided. For the purpose of just expediting the review and analysis to bring a level of confidence to whoever may lack confidence, I don't know who they are, but to bring that to bear. The other thing that I think is quite interesting and much appreciative is that your review seems to imply that much of the issues that we face are mechanical, systemic, and institutional. So we look forward to the CROS project being sort of supports the necessity for CROS in order to be able to address many of these issues that we have disclosed, as well as the institutional, cultural issues of reconciliation. Glad you brought that forward. And so if we get the systems in place and the staffing trained, I think we'll be able to get there. So thank you very much. Very much appreciated.
Thank you. Okay, seeing no further comments, thank you for your presentation. Ms.
Thank
Bridges?
you.
Thank you.
Ms. Finley, thank you. Okay, next item, Ms. Richmond.
Our next item is P1.2 Report on Time Extensions to Calaveras and San Luis Obispo counties.
Mr. Yao, welcome. Please introduce yourself for the record. And
Good afternoon, Chairwoman Ma and members. David Gao, Chief Deputy Director. The first item is Revenue and Taxation Code 155 requires a report on extensions that are granted to county assessors for their submission of the local assessment rolls. This is merely to inform you that a 30-day extension has been granted to 2 counties at this point, Calaveras County and San Luis Obispo County. That concludes the report on that item.
okay, any discussion, members?
No.
No, this doesn't require a vote, so we will move on to the next item.
Our next item is P1.3 Update on Operational Issues.
David Gao, Chief Deputy Director, Chairwoman Ma and members. Just like to take a few minutes to update you on some operational issues inside the agency. First, I would like to express my appreciation for your willingness to take on the extra workload associated with filling many vacant CEAs we have around here. As you know, we're in the process of actively recruiting for multiple CEA positions, and we look forward to these positions being filled so that we can round out our executive team. Specifically, we're in the process of recruiting for the Business Tax and Fee Deputy Director, the Chief Technology Officer, which will oversee the CROS project as well, the External Affairs Deputy Director position, as well as the Chief of Special Taxes Policy and Compliance Division. Next, I'd just like to update with some CROS comments before Ms. Fleming comes forward. This is, I'd like to emphasize, I guess, the significant undertaking that that project is going to be for this agency and over the next several years. And that's going to be our primary focus. And due to the workload demands of that project, work on additional IT-related projects is going to really be a challenge around here. So I just wanted to, I think we need to continue to message that and just know that our focus will be on that CROS project. I'm going to have a management meeting May 10th in Irvine. This is a great opportunity for management across the agency to get together and communicate with each other. My goal is to have 3 of these a year. I'd like to do one in Northern California, Southern California, and one here in Sacramento. So again, May 10th, and we look forward to that meeting. Then next up is messaging on our strategic management plan. We're going to begin doing that very shortly. We will start rolling out. We've been looking at different presentations, posters, those kinds of things. And what I'd like to do this year is really have it kind of be a participatory effort with the districts. I'd like to have them kind of take a look at some of the graphics and, excuse me, have them put maybe some people from their districts in the pictures, what may work well in a certain area that they like to see colors and graphics. So we'll be discussing that a little bit at our May 10th meeting as well, so that we can just get those messages out there, make them public, and really start working on the messaging part of the management plan.
And did we ever see the whole management plan?
I presented that maybe 2 or 3 months ago to the board, yes.
Okay.
and I'd be glad to present it, provide it to the members again. So. For your information also, the Assistant Chief of Field in District 3 is working on a study regarding the field audit program to look at audit coverage as it relates to existing resources. The Field Operations Department will provide additional information at a later date, so it's just kind of an information item at this point. And related to our expenditures, I would just an update there. We're 2/3 of the way through the year, fiscal year, so this would be where we'd be at about 66.6%. So currently, we're at 64.21% for our personal services expenditure. So that's our salaries and wages. So we're a couple percent under there at this point in time. And we're at 65.71% for our operating expense and equipment expenditures. So we're just about 1% or a little more under where we would be at this point. So we're in good shape overall. We're at 64.58% for overall expenditures at this point in the fiscal year. So we're back in line, and we are, as mentioned in the previous report, recruiting vacancies as aggressively as we possibly can and staying within our budget. And then lastly, I know it came up this morning in the Legislative Committee, the item of the cash acceptance. So I thought I would just mention what we are doing in that regard. We have a request for information on the streets, publicly being advertised at this point. And what we're really looking for is experts in the field, vendors that may be having some kind of machines, kiosks, we call them cash acceptance machines, to submit whatever they can to us as far as information on their products and whether we can ultimately go to a request for a bid and maybe look at how do we not have to accept cash in the district offices, or maybe they can be remotely, or they can at least be done through an automated system. We don't know, and that's why we're going out with this request for information at this point. And then we would ultimately maybe be able to bring the vendors in, see what kind of options there are, and then ultimately could do a request for bid and procure something for that. That would, again, I think that as the members were discussing this morning, the safety of our employees is of paramount concern for everyone and all of us. We've been doing internal things to working with all the districts to make sure that we can be as safe as we can. And I think this would help too, is if we could find some kind of a kiosk or automated system as well.
And what's the timeline for this RFI?
So, yes, April 4th is the first request deadline for the request for information. So that will be coming to us shortly. I would, based on the calendar, I think around this summer, maybe late summer-ish is when we could probably have something looked at as far as having something in some of the offices, at least a proof of concept or something. I mean, we may have to look at a couple things and try a couple out, just do a proof of concept. So.
And then do we have to go for the RFP or?
Yes, that is included in that schedule.
Okay,
so
summer.
The idea is that we would go out for an RFP
Okay,
after next. Yeah.
Okay.
So again, just a quick update on that. That concludes my operational update.
Any questions? Members? No? Okay, seeing none. Thank you very much, Mr. Gao.
Okay.
Next item.
Our next item
Richmond?
is P1.4 2015-16 State Employee Food Drive results.
Very good. Well, this is an exciting presentation. I'm here to report on the 2015-16 State Employee Food Drive results. Mr. Andrew Reed is joining me. He was the chair of this year's food drive, and just to kind of set the stage for him, once again, the generosity of the board employees, is unsurpassed. BOE ranked number 1 out of 95 participating state agencies and contributions to the annual holiday food drive. Yes. And just for comparison purposes, last year BOE employees collectively donated 164,156 pounds of food. This year, employees surpassed last year's collection by donating 183,696 pounds of food, and of that total, 111,929 pounds were donated by the district offices. So with me here today is Andrew Reed, and he will provide more information on the results of this year's food drive.
Thank you very much. Good afternoon, Chairwoman Ma and honorable board members. My name is Andy Reed, and as Mr. Gao said, I was the chair of this year's 2015 BOE Holiday Food Drive. And I would just like to say it was an honor to serve as the chair of this year's food drive and work with such outstanding vice chairs, key campaigners, and staff to make this such a successful effort. The state partner in this year's food drive was the Sacramento Food Bank and Family Services, and they provide free emergency goods and services through itself and partner agencies to 150,000 men, women, and children every month. BOE's hard work and generosity resulted in, as Mr. Gao mentioned, BOE being number one in food donations out of 95 state agencies who are participating, donating food donations of 112,000 pounds, number one in monetary donations, close to $29,000, and number one overall in pounds donated, 183,696 pounds. So it's great being number one in all these categories, but what's important to remember is that BOE helped improve the lives of those in the communities around the state where we live, work, and play, and by donating overall a whopping close to 184,000 pounds of food, which is nearly a 12% increase over last year. So I'd like to take a moment to acknowledge the top performing departments, which were number one, special taxes and fees, came in at 12,400 pounds. Technology Services Department at almost 12,000 pounds. Sales and Use Tax Department at 11,620 pounds. For the district offices, Riverside, they donated 34,303 pounds. San Diego, 27,278 pounds. And Fresno, almost 13,000 pounds.
Flex your muscle.
And in terms of pounds per employee, Sales and Use Tax, Deputy Director's Office, 57 pounds per employee. Legal Appeals Division, 41 pounds per employee. And Property Tax, County Assessed Properties Division, 32 pounds per employee. So a huge thanks to all of BOE. The outpouring of enthusiasm and willingness to give has been overwhelming and made this year's food drive a smashing success. So this pretty much sums up the results of this year's food drive. Thank you so much for your time and your attention.
I do have a question. When you talk about pounds donated, is it people that are buying canned food or putting it in a barrel, or how does?
Yeah, it's people donating straight food. It could be cans of food. It could be potatoes. It could be rice. So
the heavier the better, then.
The heavier the better.
I know, that's what I'm trying to figure out. Like, none of my offices are on there, so I'll bring potatoes or watermelons or something next year. I don't know.
Potatoes were a biggie. Carrots were a biggie, yes. And if you donated money, it's 2.5 pounds per dollar. Per dollar. It's the equivalent. So your $30,000 came to, what, almost $75,000?
Okay.
Or 75,000 pounds, I'm sorry.
Right, great.
Huge.
Any other? Mr. Horton.
I just wanted to extend my appreciation to all of you. You know, we get to see often the members as representatives of the board. We get to hear the stories that you create by your generosity when people come up to us and express their appreciation. And so as a conduit, we want to share those mountains of appreciations that we see periodically. In the United States, unfortunately, 1 out of every 7 persons face hunger. We wouldn't believe that was the case here in a country such as the United States of America. In California, 47% of our senior citizens can't afford their basic needs. 25% of our residents live below the poverty line. Los Angeles County, 45,000 homeless individuals. I share that only to say that it's extremely, extremely important, the work that you do, no matter how small of an amount or how large of an amount, it's extremely important. And to thank my colleagues as well for the support over the years that we've done this. That is the real, significant.
And what is the food drive duration? When do you start and when do we end?
Was November 9th until January 15th, so just a little over 2 months.
January 15th. Okay, great. Any other?
She's getting ready to buy those taters.
Hey, I'm like going to start blasting down my newsletter. Get ready. November 9th. I'm super competitive, for those that don't know me. Well, okay. Anything?
May I pose
Thank
upon
you.
the board for a photo
Yes,
opportunity?
that would be great. Thank you. All right.
And can I invite Julia to come down? And we have some of the vice chairs here also.
Okay.
Sure. Yeah?
Great.
I can stand in the back.
Like, not against another trend.
Three, two, one. One more. 3, 2, 1.
You want to take a camera? Facebook.
Social media, come on, get the social media going here.
3, 2, 1.
Venus can do this. Here's the social media, folks. Selfie stick. Selfie stick out there.
One more.
Oh, okay. Hey, thanks. Thank you very much.
And stock it up. And send it to me? Right.
Yeah, here comes the potatoes.
All right. Okay, the next item, Madam Clerk, Ms. Richmond.
Our next item is P1.2 Employee Recognition Award Program.
David Gow, Chief Deputy Director, Chairman and members. Today for your approval are the recommended nominees for the Employee Recognition Awards. Submitted nominations were reviewed by department heads, and the list of recommended nominees was provided to you. There are 5 nominees for each district from headquarters and also from the out-of-state offices. The recommended individual award recipients are nominated by category, which includes customer service, extra mile, innovation, leadership, and supervisory excellence. We also have 2 group awards, one with 31 recipients and the other with 4. The category for these awards is teamwork. Upon your approval of the nominees, we would like to hold a ceremony in April in Culver City for the Southern California Award recipients, and then hold a ceremony in May in Sacramento for the Northern California recipients. So may I have your approval, please?
Youth may.
Yes.
Yes. Unanimous support.
Thank you. That concludes my report.
Okay, Madam Clerk, next item.
Our next matter is item P6, Administration Deputy Director's Report. Item P61, contracts over $1 million.
Okay, welcome, Ms. Murphy. Please introduce yourself for the record and commence with your presentation.
Thank you. Good afternoon, Chairwoman Ma and members. I'm Edna Murphy, Deputy Director of the Administration Department. Before you today is a request for approval of 3 contracts over $1 million. The first contract is with the Department of Motor Vehicle. This is a renewal of our interagency agreement with them to provide services to collect use tax on the transfer of vehicles by private parties and is consistent with prior agreements. The total amount for fiscal year 16-17 is $6,558,000. The annual estimated revenue collected by DMV for this effort is approximately $565 million. The second contract is a renewal of the interagency agreement with the Department of Toxics and Substance Control to reimburse BOE for our costs to administer the Hazardous Substance Tax Program by registering taxpayers, assessing fees, processing returns, depositing payments, and performing audit and collection functions. The total amount of reimbursement requested for fiscal year 16-17 is $5,185,000. The annual estimated revenue collected by BOE for this effort is approximately $85.2 million. And lastly, we have a contract renewal for the Department of Resources, Recycling, and Recovery to reimburse the BOE for a portion of the cost to administer the California Tire Fee Program, again by registering taxpayers, assessing fees, processing returns, and depositing payments and performing audit and collection functions. The total amount of reimbursement requested for fiscal year 16-17 is $1,023,000. The annual estimated revenue collected by BOE for this effort is approximately $56.4 million. If it pleases the board, I would ask for your vote of approval to enter into these contracts.
Motion to approve.
Second.
Okay, Ms. Harkey made a motion to approve all 3 contracts. Is that correct?
Correct.
All 3 contracts. Ms. Stowers seconded. Without objection, motion carries.
Thank you.
Okay, Ms. Richmond, next item.
Our next item is P7, Technology Deputy Director's Report, P7-1, CROS Project Update and Actions.
Welcome, Ms. Fleming.
Good. I was going to say good morning, but good afternoon.
Please introduce yourself for the record and commence
you.
with your
Thank
presentation.
you.
Thank you.
Madam Chair, Madam Vice Chair, and distinguished and honorable members. I'm Brenda Fleming, the Chief Information Officer for the agency and Deputy for the Technology Services Department. It's a pleasure to be here with you. I'm pleased to report that our CROS project continues to make good progress. The project is still in the procurement phase. However, the proverbial light at the end of the tunnel is close. As an update for you, the proposals have been reviewed, and the California Department of Technology has confirmed for us that we are now prepared to move into negotiations. This is a significant milestone for the Board of Equalization, and I'd like to pause and give a shout out and thanks to all of the people who contributed to that. That's a really, really major accomplishment. Woo-hoo! Go team! I look forward to sharing updates on the negotiations as they progress, and we'll actually be starting some of that activity next week, so I'll definitely keep you posted. Beyond the procurement, we are optimistically expecting to have the vendor on board later this year. During the interim, the project team is working closely with all BOE departments to get our agency fit and ready for the implementation marathon that lies ahead of us. I'd like to highlight some of this month's accomplishments. For example, a number of BOE staff with expertise in key subject areas have been identified to ensure efficient reviews of the vendor's materials and deliverables, and that's going to be key. Many of BOE's forms and reports have been streamlined for consistency in preparation for the new system. Our process flows continue to be reviewed and documented to ensure successful data exchanges with our external partners and internally also. A master schedule of operational and project work agency-wide has been developed and is being reviewed. This information allows us to balance, as Mr. Gao indicated before, allows us to balance the operational work with the keep the lights on kinds of activities with the attention and the staff resources that are going to be needed for the project, and it's going to be quite a balance. Our budget documents for 2016-2017 fiscal year have been prepared and they have been submitted for consideration by the Department of Finance and the Legislature. The recruitment and hiring activities to fill the project director position are in progress. The organizational change management core team members are developing materials needed to keep managers and staff in the field, out of state, and the HQ offices informed in preparation for the implementation activities. From a budget perspective, what's been accomplished this period is in January of 2016 through January of 2016, the project spent February, the project has actually spent $457,201. And to date, they spent approximately 61% of the fiscal year 2015-2016 budget, so good shape. Planned activities for the next month. We'll continue working with the Department of Technology on the next steps in the procurement phase, specifically the negotiations as we mentioned, and continue with the Get Fit and Ready activities led by our fantastic organizational change management team. Honorable members, this Fit and Ready campaign is modeled after the fitness training approach that distance runners use in preparation for marathons. Since the path to our new system will take some time, we want to make sure that we are fit and ready to successfully implement a new tax administration system that benefits our taxpayers and our BOE employees. During this next month, we'll focus on preparing BOE for the race. We'll focus on A, what's needed to transition from the legacy systems, IRIS and ACMS, which you've heard in Ms. Finley's report, has some restrictions as to what allows us to use moving forward with our accounting activities. Also, what's needed to perform our core functions, like registration, collections, et cetera. The Fit and Ready campaign will be facilitated by, again, our great organizational change management core team, a group of managers that represent all areas of the BOE, both in the field offices and in headquarters. They understand the work processes and unique needs in their areas and are committed to ensuring that everyone can contribute to our successful outcomes. We look forward to sharing more information about this campaign over the next few weeks and months. That concludes my presentation. Please let me know if there's any questions. I thank you for this opportunity.
Any questions, members? Ms. Harkey?
No, I want to thank you for stopping by the office and explain where we are. I feel very confident with where you're going. As you know, mine are change order oriented. I want to limit as much possible for those.
Absolutely.
But I think you're on a good path, and I appreciate what you're doing. Thank you.
Okay, I appreciate it. Thank you. Thank you.
Ms. Towers?
I also want to say thank you. I'm looking forward to your Fit and Ready campaign.
Thank you.
So, sure we're ready.
Okay, I appreciate it. We appreciate your support.
The end of campaign.
Okay. Thank you, Ms. Fleming,
Thank
for your
you.
presentation. Next item, Ms. Richmond?
Besides the approval of the board committee reports and approval of the committee actions, that approves the administrative session. Would you like to go into closed session?
Yes. Okay, can we approve the minutes coming out so I can take a look at it? Yeah.
Yes,
So
we're
we're going to
still
move
waiting
into
for
closed
property
session?
tax and business tax.
Okay. We're going to take a 5-minute break, and then we're going to go to closed session.
Okay. You get a copy of property tax.
Huh?
You get a copy of the property tax.
I don't have it.
Okay, I'll give it to you.
Where is he?
Members of the Board of Equalization want to hear from you. If you have ideas, concerns, or suggestions on how the board could improve services and the taxpayer experience, make sure to attend the annual Taxpayers Bill of Rights hearings in Culver City on April 26th or Sacramento on May 24th. If you'd like more information, visit boe.ca.gov.
Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you. Good for California.
part, so do we say we're back in session?
Yes, the board members
Okay,
met in
Ms.
closed
Richmond?
session and discussed settlements, pending litigation, and personnel matters.
Okay, so I'm going to report out from closed session. The board is pleased to announce the appointment of Chris Cayetti to the position of Chief Technology Officer, Centralized Revenue Opportunity System. The board is also pleased to announce the appointment of Suzanne Bueller to the position of Deputy Director, Business Tax and Fee Department. Both positions are effective immediately. Please join me in congratulating both of them to the BOE executive team. The board has also appointed Cynthia Bridges to the class of Special Consultant effective April 1st, 2016, for a term of 3 months through June 30th, 2016. The board also appointed David Gao as Executive Director effective April 1st, 2016. Congratulations. Those are the items out of closed session, and Mr. Horton has some final agenda items or announcements.
In addition, Madam Chair, taking up the Property Tax Committee meetings
Oh,
and so forth.
yes.
Your desire?
Do we approve the minutes individually or approve them all at once?
It's up to you.
I move we adopt all the minutes, property tax discussed today.
The only minutes we don't have are business taxes,
Correct.
and those will be reviewed at our next board hearing.
We'll put them over? Okay.
Yes.
Okay. The ledge committee minutes were fine.
All right, thank you. Members, we all know this gentleman by the name of Percy Pinkling, and he was a dear friend to many in this business. He is also a legend by his own right. I mean, Percy dates back to, well, before I even thought about politics, and has done an exceptional job as the advisor to Dianne Feinstein. I believe he served under Jerry Brown when he first got started. He may be one of the few individuals who worked with Jerry Brown in a leadership role when he first started, his father, and every other Brown thereafter. So I'd like for us to adjourn in his memory if we can, Madam Chair. I also want to acknowledge Shelley Hughes, my advisor. She's also my chief counsel. She's done an exceptional job for the Board of Equalization as well as for me. And she is moving on to be the Deputy Executive Director for the State of Nevada Property Tax Committee, which is a huge promotion, huge opportunity. She will serve as well as we begin to take over Nevada. The second person is Jackie Zumata in my office. She's came to us as a Tax Counsel 1. We're pleased that she is going back to the Franchise Tax Board as a Tax Counsel 3 to provide some insight as to what she's learned while being here at the Board of Equalization, and she's done a fabulous job. Congratulations, Jackie. And lastly, Camille Dixon, who is also elevating to the program manager for the Department of Insurance. And she has already taken her job. I'll tell you guys a story. Like, Camille was with us through the end of March. And I was out in the field sometime in February, and I asked one of the Department of Insurance people, hey, have you heard that Camille is coming over there? They said, yeah, and she's doing a fabulous job right now. You know, and I'm like, well, she hasn't left yet. So it was kind of telling, but she's doing an exceptional job, you know, as a colleague, as well as an associate to the folks and a team member to the folks that we work with. It's always gratifying when they have an opportunity to advance their personal as well as their professional career. So I'm excited for all of them and look forward to the new cadets' opportunity to move them forward as well. Thank you, Madam Chair.
Thank you. Okay, seeing no further items, Ms. Richmond, we can adjourn the meeting.
Yes, that concludes our business for this board meeting.
Okay. Thank you very much, everyone.
Thank you.